we call our expert first. If you got it, I can start whenever you're ready.
Okay.
Oh, did I tell you about the tornado second?
Good morning, Judge.
Good morning. I believe we have all but our witnesses. Do we have David Rothwell or Emma Lottie? We have a witness.
We're both here.
We're both present.
Okay, great. So I believe we have everyone here. Welcome to our court in this competition. As you may obviously know, it's in Waco. In May of 1953, there was a devastating tornado in Waco. And so since that time period, I believe it's one of the Fridays of each month at 10 o'clock, we have a tornado signal practice. And so we will be hearing in 3 minutes, perhaps, that warning. So please understand that. But for now, I'm going to go ahead and call the case of Jordan Gilmore versus Chimes Department Stores, Inc. In the District Court of McLennan County, 170th District Court. Does the plaintiff, are you ready to proceed?
Good morning, Your Honor. My name is John Banks, and I, along with my co-counsel Riley Davis, represent Jordan Gilmore in today's case. We have a few housekeeping matters to take up in the court whenever you are ready.
All right. Defense announcements.
Good morning, Your Honor. Carolyn McWiggin on behalf of the defendant, Chimes Department Stores Incorporated. And today I am joined by my co-counsel, Chehek Goja.
Do you have any housekeeping or pretrial matters?
We do have a few housekeeping matters, Your Honor, before we get started, yes.
Let's start with plaintiffs. First, housekeeping matters.
Yes, Your Honor. May we assume that all witnesses have been pre-sworn?
Correct.
Your Honor, both live witnesses in today's trial are parties. Therefore, the rule does not apply and no witnesses may be sequestered under the rule.
How is the witness for Chimes Department Stores a party?
He's the corporate representative of the defendant corporation, Your Honor.
Is that correct? Defense counsel?
Yes, Your Honor. Ms. Giller is the owner of Chimes Department Stores Incorporated.
All right, sir. So acknowledged. Anything further?
Yes, Your Honor. When handling evidentiary arguments, may we assume that we are outside the presence of the jury?
Absolutely.
Once Your Honor has made a ruling, may we also assume that we are back inside the presence of the jury?
You may.
Just to remind Your Honor, this case is bifurcated and today's trial only deals with liability.
I understand that there is a requirement of establishing a prima facie case of duty, breach, proximate cause, and damage. I'll give you only little leeway on the issue of damages.
Yes,
Anything?
Yes, Your Honor. Based on our meet and confer with opposing counsel, we have stipulated to pre-admit a number of exhibits.
Makes my job easier.
Exhibits 3, 6, 11,
11.
12, 17, and 19.
Okay. Is that correct, defense counsel?
That's correct, Your Honor.
All right. So those matters are admitted for all purposes?
Yes, Your Honor. Also, during our meet and confer, we discussed a potential motion to eliminate with opposing counsel, and both parties have stipulated to the lack of use or mention of Exhibit 37, which was a proposed but not adopted OSHA regulation.
Okay, so That will not be in evidence and not referred to in any way. Is that agreed, defense counsel?
Yes, Your Honor.
Okay.
And lastly, Your Honor, we have deposition testimony meeting the requirements under 804 for an unavailable witness that will be read during the course of today's trial. We've discussed the portions that will be read aloud with opposing counsel.
Hold 1 second.
Yes, Your Honor.
It doesn't last very long. And having actually appeared in the 170th many times, I can assure you it's a lot louder in the 170th. Can y'all hear it at all?
No, sir.
I can't, so please understand, counsel,
Yes, Your Honor.
I owe you my undivided attention. So. Proceed, counsel.
Yes, Your Honor. There is deposition testimony that meets the requirements under 804 for an unavailable witness that will be read in during the course of today's trial. We have discussed the portions that will be read out loud with opposing counsel during meet and confer, and they have only one request for constructive redaction based on our witnesses' portions that will be read aloud.
And do you agree to that redaction?
Yes, Your Honor.
So for your deposition read, and who is that, counsel? Kelly
I'm
Dane.
sorry, what was that, Your Honor? I didn't hear you.
My understanding, plaintiff's counsel has conferred with you on the deposition of Kelly Danes, and what will be read is agreed to.
Yes, Your Honor, provided that the plaintiff's counsel is agreeing to the redaction that we requested for page 9, line 23 to page 10, line 2. If not, we will be dealing with that objection at the time that we do the read-ins before Your Honor.
That's what I'm trying to have a clear understanding. Has that been agreed to or not, counsel?
Yes, Your Honor.
Okay, so we're good to go on the deposition of Kelly Dane. All right.
One last thing, Your Honor. Do you have a preference in terms of seeking permission to screen share for the purposes of a demonstrative or a exhibit that's already in evidence?
I do not, unless you are not clear and deliberate in your screen share presentation. If you take advantage of that, I will call you out on it.
Yes, Your Honor. And that's all for plaintiff's housekeeping. We're ready for opening statements when the court is.
All right, defense counsel.
Yes, Your Honor. We will also be reading in portions from a deposition of a witness who is unavailable under Rule 804. It is our intention to offer the deposition in its entirety with some constructive redactions that we have agreed on opposing counsel with prior to this. And then we will highlight certain portions pursuant to Federal Rule of Civil Procedure 32 so that the jury may hear them. And additionally, Your Honor, we didn't.
Wait a minute, counsel. What do you mean you're going to highlight portions?
Your Honor, we will constructively read in the deposition in its entirety with certain redactions that we have agreed on. And then we will, in a question and answer style, read out verbally so that the jury may hear certain portions of that testimony that is being constructively entered into evidence.
Now, just for everyone's clear understanding, when you're saying that constructively offer, you're not going either side, you're not going to actually read the deposition. Is that correct, plaintiff counsel?
Yes, Your Honor.
Is that correct, defense counsel?
I'm sorry, Your Honor, perhaps I'm a little bit weak.
Constructive means we're not going to actually read the deposition other than what you're referencing as highlighting portions.
That's correct, Your Honor, yes.
All right, proceed, counsel.
And additionally, Your Honor, we had intended to make 2 motions in limine to preclude 3 exhibits. However, we have agreed prior to trial with opposing counsel that those exhibits will not be entered into evidence or referenced today. They are exhibits 8 and 9, as well as exhibit 40.
Again, makes my job easy. Anything else?
That concludes our housekeeping, Your Honor. We're ready to proceed to openings.
All right. Having concluded the housekeeping and pretrial matters, now call for trial the case of Jordan Gilmore versus Chimes Department Stores, Inc. And ask, is plaintiff prepared to make an opening statement?
Yes, Your Honor.
You may proceed, counsel.
May it please the court. Some people want all the control and none of the responsibility. This defendant wanted all the control over their landing behind their store, but none of the responsibility that comes with their neglect. The defendant, Chimes Department Stores, operates a department store that sells everything from shoes to tools right down on Bosque Avenue. And Chimes has been around for a couple of decades. It was founded by the current owners, Reese Geller's grandparents, who then pass it down to Mr. Geller's parents, pass it on to Mr. Geller. In 2015, the store was doing well. So good that the defendant outgrew the location they were at the time. Needed to find a bigger space. That's when they found the space they are currently in and have been in for the last 15 years. But when the defendant moved in, they started making some changes, some structural changes. See, the defendant sent a request to the landowner, Kermit Realty Group, to take down some guardrails and handrails out back so they could use the area as a loading dock. But not only did they make the request, they paid for these changes to be made. And you will learn today that by exercising control over that area, by paying for those changes, they also accepted the responsibility for any harm that would occur back there. And on January 23rd of 2019, there was a harm. Jordan Gilmore was harmed on the back of the store. I want all y'all to meet Jordan. Jordan, would you turn on your camera and say, hey, for us?
Hello.
Now, Mr. Gilmore worked at Chimes for about 10 years as a cashier. He'd be up front, check folks out, help them ring up their items, and take the trash out back every once in a while. Thank you, Jordan. You can turn your camera off. Now, Jordan has now stopped smoking, but when he was still an employee of the defendant, Jordan was still a smoker. And on January 23rd of 2019, during one of his smoke breaks, Mr. Gilmore fell from the defendant's landing and tore up his knee. Being the middle of January, it was cold that night. Mr. Gilmore and another employee, Riley Hertzberger, went out to the landing to smoke because that is where the defendant told their employees they had to. It was around 7, 2 hours after sunset, so it was dark. It was pitch black because the one light that was outside wasn't on. And despite multiple employees complaining about this light never being on, all the defendant could say is they didn't have access to the switch, so there was nothing they could do about it. Leaving their employees, just like Mr. Gilmore, to go outside on their back landing area with no rails, take a smoke break at night. So Mr. Gilmore is on the platform. No handrails, uses the wall to brace himself as he walks down the steps, afraid of letting the smoke drift back in the building. His co-worker, Ms. Hertzberger, stands at the top of the landing, holding the door open so some of that light from the inside can leak out. They can see something. That landing dock. Now, Ms. Hertzberger was at the top, holding the door open, but not like you see in this picture. You see it's flush, goes down about 2 steps. Ms. Hertzberger was holding about halfway open to where it was blocking the middle of the steps. So Mr. Gilmore tries to make his way up the steps, using the wall at first, but then starts moving over. Closer to the exposed side with no rail, and tries to step his right foot on that platform when something happens. He feels his right foot slip, knowing he can't do anything else, and tries to jump so he doesn't face plant. He lands, tears up his knee a little bit, and falls on his rear. As the plaintiff, we've brought this case against the defendant for negligence and will prove to you that the defendant was negligent, that the defendant failed to use ordinary care to protect Jordan Gilmore by showing you three things. One, that the defendant knew that the landing posed an unreasonable risk of harm. Second, that the defendant failed to make the landing safe. And third, that the defendant exercised control over the landing and the surrounding area. Now, to explain to you how the landing posed an unreasonable risk of harm, we will call Ms. Kelly Dames to the stand. Ms. Dames received her bachelor's of science in mechanical engineering from the University of Wisconsin before later becoming a registered professional engineer in 7 states, including ours. Ms. Dames has been used in about 60 cases just like this one. Ms. Dames is here to tell you that based on the International Building Code and regulations from the Occupational Safety and Health Administration, known as OSHA, that the defendant failed to keep the landing area up to code and properly maintained, which created an unreasonable risk of harm to the defendant's employees. Second, we will show you that the defendant failed to make the landing area safe. Not only did the defendant not meet the proper OSHA and IBC regulations on hand and guardrails, but the defendant also failed to make sure there was adequate lighting in the landing area. And lastly, we're going to show that the defendant exercised control over the landing and surrounding area. The law of our state provides that a tenant is responsible for areas it leases, and those areas next to and hitting the leased area, which it actually controls. And that control can be proven by an actual exercise of control. You will learn that the defendant exercised control over the landing area by directing the removal of the guardrails, directing that a concrete drive-up be poured up to the landing area, by paying for these structural changes, and by directing their employees to work and even smoke in that landing area. Some people want all the control and none of the responsibility. This defendant took all of the control over the landing behind their store, but wants to take none of the responsibility that comes with their neglect. Make the defendant take responsibility. Find for Jordan Gilmore.
Does Spence wish to make an opening statement?
Yes, Your Honor. Before I begin, may I just have a brief moment to set up the courtroom?
You may.
May I proceed, Your Honor?
You may.
Jordan Gilmore had a terrible accident. You're not going to hear us say any different today. And we understand why Mr. Gilmore wants to hold someone responsible. But today, the plaintiff will try to pin responsibility on the wrong people. because Chimes department store did not control the loading dock where the plaintiff fell. And they didn't control the plaintiff's own choices. Without control, there is no responsibility and there can be no liability. Members of the jury, today the evidence will show that Chimes department store was not responsible for maintaining the space where the plaintiff fell, and that the plaintiff's own choices are what actually caused his injuries. Now, before we go any further, I want to take a minute to tell you a bit about Chimes department stores. Chimes is a small town department store located right here in Waco. They're a family-run business. They were started 2 generations ago by a husband and wife. And today, Reese Gilmore, that husband and wife's granddaughter, owns and runs the store. You're going to hear from Reese today, and she's going to explain that Chimes leases its storefront from a company called Kermit Realty LLC. And as part of the terms of that lease, Chimes leases a specific area of the store, and that area, Reese will tell you, ends with the back wall of that store. The space beyond that wall, the space where the plaintiff fell, is not covered by that lease. So you'll learn that means that whatever happens in that area, whatever improvements may or may not need to be made, well, those fall squarely on the shoulders of Kermit Realty LLC, the owner. Chimes department store had nothing to do with it. Now, today the plaintiff won't be able to prove anything to the contrary. They have to prove first, before they prove anything else as a threshold matter, that Chimes department store controlled that area. They won't be able to do that. Instead, they'll call Kelly Danes, a mechanical engineer who's you'll learn is being paid to offer her opinions here today. But money or not, Kelly Danes will not be able to show you anything that proves that Chimes department stores actually controlled that area. Instead, you'll learn that this was a common area, which pursuant to the terms of the lease is something that can be accessed by all tenants and something that the landlord was responsible for maintaining. Now, right then and there, the plaintiff's case will fail. Because if they can't prove control, there's no responsibility and there can be no liability. But then Kelly Danes also won't be able to tell you that there was actually anything wrong with the way that area was maintained. You'll hear about OSHA and IBC regulations today. Those are federal and state regulations that tell employers that they have to do certain things to keep their employees safe. Now, you'll hear about those regulations, but when you do, ask the plaintiff to show you that the regulations they'll talk about apply to loading docks. They won't be able to do that. So you'll learn that means those regulations, they don't apply to this case and to this accident. Now, we, on the other hand, will bring you Perry Hayden, an actual OSHA investigator who's not being compensated for her time here today. Ms. Hayden will tell you that her entire job is to investigate workplaces to determine whether or not they are up to code with federal standards. And she'll tell you that in 2018, when she investigated the Chimes department store, the very store that we're talking about here today, she did not issue a single citation. She saw all the things the plaintiff claims makes this loading dock so dangerous. She saw the lack of guardrails. She saw the way the door opened. She saw all of it. And she still did not find anything that warranted issuing a citation. You'll learn that's partially because these regulations applied to loading docks, and this was not, in fact, a loading dock. But you'll also learn it's because there was nothing actually wrong with the way the area was maintained. Chimes department stores did not have control over that area, and the plaintiff won't be able to prove any violations. So there can be no liability. No control, no responsibility, no liability. The members of the jury, there's one more thing you're going to have to consider today. The unfortunate truth that Jordan Gilmore's choices are responsible for what happened to him. Now, we are in no way saying that Jordan Gilmore is a bad guy or that he acted egregiously. Instead, he just made a mistake. It was wintertime, it was dark, it was cold, and he went out back for a smoke. And when he came back up those stairs, he saw that the door was half open. He saw that there was only a little bit of space on the landing where he could get around that door. Now, he could have chosen to ask Riley, his coworker, to open that door all the way. He could have chosen to ask her to move so he had more space. He could have chosen to ask her to close the door so that he'd have more space to get up onto that landing safely. The evidence will show he didn't do that. Instead, he tried to scoot around the half-open door, stepping all the way to the edge of a ledge that he knew did not have a guardrail. Unfortunately, he fell and he was injured. But members of the jury, today the evidence will show that those consequences were a result of his choices. Chimes department stores had nothing to do with it. Members of the jury, at the end of this trial, when I come before you again, you will have learned 3 things. First, that Chimes department stores did not control the loading dock where the plaintiff fell. Second, that loading dock is not actually subject to the regulations that you will hear about today. And third, the plaintiff's own choices are responsible for his injuries. Chimes department stores did not control the area, and they didn't control the choices that Jordan Gilmore made. Without control, there is no responsibility, and there can be no liability. As such, at the end of this trial, after you've heard all the evidence and the testimony, I'm confident that you will be able to return the only verdict that justice allows. A verdict finding Chimes department stores not liable. Thank you.
Plaintiff calling the first witness.
This time, plaintiff calls Jordan Gilmore to the stand.
Mr. Gilmore, having been previously sworn, you may proceed, counsel.
Yes, Your Honor. Please introduce yourself to us.
My name is Jordan Gilmore. I'm 48 years old and lived in Waco pretty much all my life.
Well, you've been in Waco for a while. Have you had any jobs in town?
Yes, I used to work for Chimes department store.
How long did you work for Chimes?
Probably about 10 years.
When you weren't working for Chimes, what'd you do?
I'm a Baptist, so going to church on Sundays, going to Sunday school, 7th and James Baptist Church, and also book club every Wednesday. And then I like to have friends from Sunday school over. We play cards every now and then.
Mr. Gilmore, I want to talk a little bit more with you about your 10 years at Chimes. What did your job as a cashier require you to do?
I was checking people out, interfacing with the customers, trying to, when they're done shopping, ready to purchase, every now and then I'd go out, take the trash out to the dumpster behind, but that's about my job.
Now, you just mentioned you would take the trash to the dumpster out back.
Mhm.
Was there anything else you would do out there?
Yeah, that's where we were required to take our smoke breaks whenever we wanted to take a smoke break. So I took about a smoke break a day out there.
Now, you say you were required. Why do you say that?
Sorry, I couldn't hear you. Can you repeat the question?
Sure. You said you were required to take smoke breaks out there. Why do you say that?
Oh yeah, we were sent a memo from Chimes that basically stated they didn't want us smoking out front because bad look for the store, bad having customers coming in, walking past employees smoking. So they required us to take smoke breaks out back.
I got you. Mr. Gilmore, I want to shift gears here for a little bit and talk about what happened on the night of January 23rd of 2019.
Mm-hmm.
What do you remember about that night?
So the day kind of went by as usual. I was working noon to 8 p.m. I was working the closing shift. At about 7, I decided to go take a smoke break with Riley. So we went out back to take our smoke break.
Now, you mentioned you go out there about 7. Was it still light outside?
No, at that time of the year, it gets dark around 5:30 or 6. So it was pitch black out there.
Were there any lights out back?
There's a light out back, but it's never been on.
What do you mean it's never been on?
As far as I remember, there's a light out there. But we've asked manager in chimes every now and then to see if we could get it on, but their response has always been the light switch is in the Tractor Supply Company store next door. So they had no control over it. They couldn't turn it on because the switch was in the other store.
Okay, so you could not get the lights on, but what happened when you go outside that night?
So it was a dark, cold night. I went out, kind of walked down the steps to take my smoke break because I didn't want the smoke blowing back into the store. So as I was going down, I was kind of holding the wall for stability. Took the smoke break while Riley was standing in the door. So there was a little bit of light, but it was only coming from the store, and Riley was standing in the doorway, so she blocked out some of the light as well. And then afterwards, after I finished my break, decided to walk back in, and that's when the accident happened.
Okay, so just walk us through that a little bit.
Okay.
As you were walking up the steps, tell us what happened.
So I was walking up the steps. Riley was had the door propped open. So in order to get back into the store, I kind of had to step around the door. So as I was going to step around the door, I felt my foot slip a little bit. So I kind of figured I was falling, and I figured I should try to land on my legs. So I jumped back, and when I landed, the ground was uneven. So most of my weight ended up on my right leg, and I ended up stumbling and falling backwards on my rear.
I want to go back just for a second, Mr. Gilmore. You said you had to step around the door. Why'd you have to step around the door?
Because the door was, while opened, it was kind of blocking part of the landing. In order for me to get into the doorway, I kind of had to maneuver around the door just to get back into the store.
Citing court, opposing counsel and the witness to Exhibit 4 of the record. Mr. Gilmore, let me know when you got that pulled up.
It's not on the screen.
Your Honor, can we constructively share the screen just with the witness for the purposes of foundation?
You may.
All right, do you see that screen okay, Mr. Gilmore?
Yes, sir.
Okay, tell it, do you recognize Exhibit 4?
Yes, that's the door out back, and that's kind of the steps on the landing.
Is Exhibit 4 a fair and accurate representation of what that door looked like on January 23rd of 2019?
Yes.
Your Honor, plaintiff offers Exhibit 4 into evidence.
Defense,
No objection, Your Honor.
it is admitted.
Your Honor, permission to constructively publish Exhibits 3 and 4 to the jury at this time?
Yes.
Okay, Mr. Gilmore, I want to go back just a little bit because you kind of told us a lot. You said you try to step around the door and you feel yourself slip. What happens next?
So I kind of figured I was going to fall. I felt myself falling backwards. So I figured I'd try to jump back and try to land on my 2 feet, try to stabilize myself instead of just kind of falling back and, laying out, something like that.
So what happened when you hit the ground on your feet?
So most of my weight ended up on my right leg just because of the ground. So my weight ended up pretty much all on my right leg, and I fell backwards and landed on my rear.
What happened after you fell?
Riley came down to help me see if I was okay. She held me up and then just proceeded to slowly walk back into the store.
What happened once you got back inside the store?
I went to report the incident to the manager, Lane Kim, at the time, and basically had a conversation, and she told me that they should have had it fixed a long time ago, and that she's told management, but there's always been something more important to fix than the railing back there.
Just said that when you landed, most of your weight ended up on your right leg.
Mhm.
When you fell, were you injured?
At the time, it hurt a lot, and I did end up having to get my right knee replaced.
Pass the witness, Your Honor.
Cross.
Yes, Your Honor. Good morning, Mr. Gilmore.
Good morning.
I'm going to ask you a few more questions about what happened on January 23rd, okay?
Mhm.
First, I want to start with the area where you fell. You fell outside the back exit to Chimes department store, right?
Yes, that's correct.
That's where the loading dock is located.
Yes.
In fact, you fell off of the loading dock.
Yes.
The loading dock, that's where businesses receive shipments, right?
Yeah, that's correct.
And you're aware that loading docks don't have railings.
Yeah.
You'd agree you can't put a railing on a loading dock.
No, but on the steps you could.
Directing you back to my question, Mr. Gilmore, you can't put a railing on the loading dock, right?
No. Yeah.
It wouldn't be a loading dock anymore if you put a railing on it.
Yeah.
Now, you went out to the loading dock at Chimes department stores pretty often, right?
Yeah.
That's where you threw out the trash.
Yes.
You do that once or twice a day.
Yes.
That's also where you went to smoke.
Yes.
You did that at least once a day.
Yeah.
Between the garbage and the smoking, you'd go out to the dock about 20 times a week, right?
Yeah. Yeah. About that.
It's fair to say you were pretty familiar with the loading dock.
I'd say so.
That included the stairs
Yes.
and the lighting
Yes.
and the doors.
Yes.
Okay, now I want to talk about January 23rd specifically. Towards the end of your shift that night, you went out to the loading dock to smoke, right?
Yes.
That was around 7 p.m.
Yes.
It was nighttime.
Yes.
It was dark.
Yes.
In fact, it was pitch black.
Yes.
Now, as you said on direct, you knew the light in that area was controlled by the store next door, correct?
They had the switch. Yes.
So you knew there was no other light outside.
Yes.
The only light would come from inside of Chimes department store, right?
Yes.
And your coworker, Riley, she also went outside to smoke with you.
Yes.
She stood in that doorway.
Yeah.
She propped the door open.
Yes.
But you went down the stairs, right?
Yes, I didn't want the smoke going back in.
And so you smoked your cigarette down on the ground below, right?
Yes.
And then you came back up the stairs.
Yes.
Now, in total, you were outside for about 6 minutes, correct?
Yeah, about that.
You wanted to get back inside as quickly as possible.
Yeah, I was trying to get back in. It was pretty cold out there.
That's right. It was cold out, right?
Yes.
So, Mr. Gilmore, I want to move now to what happened after you finished your cigarette. When you were done, you came back up those stairs.
Yes.
At that point, the door to the store was still propped open, right?
Yes.
I'm showing you what's already in evidence as Exhibit 3, Mr. Gilmore.
Yes.
I apologize, everybody. It seems that I was muted there. Mr. Gilmore, this is how the door was propped open, correct?
Yeah.
And you were coming up the stairs on the other side of this door, right?
Yes.
As we can see in this picture, the door is blocking most of the landing.
Yeah.
You can see that there's only a small space on the landing where you could get around the door.
Yeah,
And you're aware this door, it actually opens further than it's opened in this picture, right?
yeah, it can be propped open.
It can open all the way.
Yes.
Now, Mr. Gilmore, I'm showing you what's already in evidence as Exhibit 6.
Wait, counsel, do we have these exhibits marked?
Your Honor, it appears that our stickers did not transfer. We did discuss this possibility with opposing counsel, and they said that as long as we indicated which exhibit it was, that would be all right.
Is that correct? Plaintiff's
Yeah.
counsel?
Yes, Your Honor, we experienced a similar issue.
All right, proceed, counsel. So we're now looking at exhibit 6.
That's correct, Your Honor.
All right, proceed.
So, Mr. Gilmore, here in Exhibit 6, this shows us what that door looks like when it's propped open all the way.
Yes.
As we can see, there's a lot more space on the landing for someone to walk up to the platform.
Yeah.
Now, when you were coming up those stairs on January 23rd, you didn't open this door all the way.
No.
You didn't ask Riley to open it all the way.
No, I was just trying to get back in.
That's a no to my question, though, right, Mr. Gilmore?
Yes.
You didn't ask Riley to move back from the door?
No.
Now, if this door had been closed all the way, it also wouldn't have blocked the landing, correct?
Yeah.
You could have asked Riley to close that door all the way,
I could have, yes.
and then you would have been able to come up onto the platform and then open it yourself, right?
Yeah.
You didn't ask Riley to close that door.
No.
Instead, you tried to step up around the half-open door, correct?
Yes.
That's when you fell.
Yes.
Thank you, Mr. Gilmore. No further questions at this time, Your Honor.
Redirect.
Yes, Your Honor. Mr. Gilmore, I want to direct you back to Exhibit 19. See that screen okay, Mr. Gilmore?
Yes, sir.
Now, at the top, in between all those wires,
Yes.
see a small white box.
Yes.
What is that?
That's where the light is, out back.
And based on what you see in Exhibit 19, where is that light pointed?
Right at the bottom of the stairs.
So right around that loading area.
Yeah.
Now I want to direct you back to Exhibit 6. My apologies. Yes, Exhibit 6. Now at that bottom right corner of the concrete on the top step,
Yes.
what are we looking at there?
To me, it looks kind of like a hole for like a post or something like that.
Objection. Your Honor, this is all outside the scope of cross-examination.
Response.
Your Honor, opposing counsel referenced the condition of the steps and this landing platform where it's simply attempting to rehabilitate what was crossed on during opposing counsel's questioning.
Very short rope, counsel.
Yes, Your Honor. Yes, Your Honor. Looking at that same corner, tell us about the condition of that concrete.
I don't know. It
Does it look broken to you?
a little bit. Yes.
And bringing back out of Exhibit 6, on those stairs, is there a handrail?
No.
Was there a handrail on the night of January 23rd of 2019?
No.
Pass the witness, Your Honor.
Anything further?
Nothing further, Your Honor.
May the witness be excused, Your Honor.
Witness is excused. Call your next witness.
At this time, Your Honor, plaintiff calls Kelly Daines by deposition. One moment while my opposing counsel gets set up, Your Honor, or my co-counsel.
Correct.
Citing court and opposing counsel to page 2, lines 12 through page 3, line 21. Question: tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure, I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically, some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
In which states are you registered as a professional engineer?
I'm currently registered in California, Texas, Wisconsin, Virginia, Louisiana, Idaho, and Washington. And I'm also registered with the National Council of Examiners for Engineering and Surveying.
What do you do professionally?
I'm the president of Daines Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Citing court and opposing counsel to page 5, line 3 through 13. Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far on this case, which obviously doesn't include my time today or my time testifying at trial, if I have to do that.
Is Exhibit 15 a true and correct copy of the invoice for your work on this case up to this point?
Yes, it is.
Do you charge the same rate for testifying at trial and deposition as you did for your previous work?
Yes.
Citing court and opposing counsel to page 6, line 10 through 23. I'm showing you what have been marked as Exhibit 16 through 21. Do you recognize these?
Yes. Those are pictures I took of the area outside the Chimes store where Jordan Gilmore fell.
Are Exhibit 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when he fell, but other than that, this is the same area and how it looked.
What do the pictures show?
Well, as you can see, there are no railings on the steps up to that landing area, and there is no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Citing court and opposing counsel to page 8, lines 16 through page 9 at line 3. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20th, 2001. The OSHA regulations were enacted into law in 1970. So both the IBC and OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
Your Honor, at this time, I request to constructively read in select portions of this deposition as well.
You may.
Page 9, line 9 through 10 at 13. Page 11, line 6 through 19. Page 11, line 24 through 12 at 14. Page 13, line 16 through page 14 at 4. Page 14, line 22 through page 15 at line 15.
Anything further from plaintiff?
And based on the testimony, Your Honor, plaintiff moves to constructively read in the statutes referenced by Ms. Daines in her opinion.
Any objection?
Yes, Your Honor, to page 13, line 17. Ms. Kelly Daines references IBC 1012.1. Your Honor, we object under Rule 106, the rule of completeness, and ask that the statute be shown to the jury because as an offer of proof, the statute will say that loading docks are exempt from the requirement that Kelly Daines cites here to have guardrails.
Reply.
At this time, Your Honor, we have no issue, but we'll take that up on defense's own expert.
Then constructively, the entirety of the statute, including the provisions cited by defense counsel, is presented to the jury.
Pass the witness, Your Honor.
Any proffer, counsel?
Yes, Your Honor, at this time, my second seat, Ms. Gogia, will join me on screen to read the answers, and I will read the questions for some brief portions of Ms. Daines' deposition.
If one moment, please, counsel, are you all seeing the blocks on the screen as I'm seeing? You've been signed out because your account is signed in from another device. Are you all seeing that?
I'm not, Your Honor.
No, Your Honor.
We're going to proceed then, because I'm afraid if I hit any button, even though I'm the son of a NASA engineer, I'll screw this up. So we're going to proceed. Go ahead, counsel.
Beginning on page 9 of Ms. Daines' deposition, line 4. Question: do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chimes store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess. My job was to look at the steps themselves and see if they met code.
Moving now to page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regard to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area.
Finally, moving to page 14, line 12. You would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock?
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, this concludes our read-in portions for Ms. Daines.
Anything further from plaintiff?
No, Your Honor. At this time, plaintiff first, Your Honor.
Anything from defense?
Yes, Your Honor, at this time, the defense moves pursuant to Federal Rule of Civil Procedure 50A for a directed verdict. Your Honor, the plaintiff had to make a prima facie showing upon which a reasonable juror could find that Chimes Department Store had a duty to maintain this area, that they breached that duty and that that duty caused injury to the plaintiff, Mr. Gilmore. As a threshold matter, they have not made a showing that Chimes department store controlled this area and therefore had any responsibility to maintain it and keep it safe. Quite the contrary, we've heard that that area was a loading dock that other tenants could access. And therefore, if no control can be established, then there can be no duty on behalf of Chimes department store to keep that area safe. Therefore, Your Honor, if there's no duty, there is no breach and no injury and can be no causation. As such, we move for a directed verdict in favor of the defense under Rule 50.
Response?
When viewing the facts in a light most favorable to the plaintiff, in this case, a reasonable juror could definitely conclude that we have made at least a prima facie showing that the defendant, Chimes, did have a duty and control over this back landing area. While defense counsel rests its case on a lease agreement, we have active and actions in furtherance of control and exercising discretion to send employees back on that loading area to take smoke breaks, to clean that area, to take company trash out of that back door into a dumpster that the company put there themselves. And lastly, that this defendant took guardrails and handrails that were once there and took them out of their original condition by paying for those services on their own, as well as installing a concrete pad to lead up to that loading dock. Based on that alone, Your Honor, there is control showing that this defendant had control. And based on defense counsel's own logic, if there is control, there's responsibility and therefore liability. And as such, the motion is due to be denied.
Any brief reply?
Yes, Your Honor. First of all, establishing that Chimes used this area is not sufficient to show that they controlled it and therefore had an obligation to maintain it. Use does not equal control. Control is what the plaintiff had to establish here, and they have failed to do so. Second of all, counsel misstates the evidence in saying that Chimes department store is the one who removed those railings. They are not. They, as an offer of proof, asked the landlord, as was discussed. They asked the landlord, and the landlord subsequently did it. It was not something that Chimes department store did unilaterally to that space, because it was not something they were able to do unilaterally to that space. Finally, Your Honor, because the plaintiff has not shown duty, they cannot show breach, injury, or causation. The inverse is not true. If they've shown duty, that does not automatically show breach, injury, and causation.
Your motion is denied. We are going to take a 5-minute break and expect you all to be back and prepared for defense to present its case in chief. Thank you.
Yes, Your Honor.
We ready to proceed, council?
Defense is ready, Your Honor.
Yes, Your Honor.
Time announcements, I believe we're fine, all things said. Plaintiff has 28 minutes remaining. Defense has 38 minutes. Proceed with your the next witness for defense.
Yes, Your Honor. At this time, the defense calls Reese Geller to the stand.
Having previously been sworn, you may proceed, counsel.
Good morning. Please introduce yourself to the jury.
Hi, I'm Reese Geller. I'm 45 years old. I live in Waco with my husband and my 3 kids. And I went to Baylor. And I've been in the Chimes family ever since I started my career.
Is that the same Chimes family that owns Chimes Department Stores?
That's right.
Can you tell us a bit more about Chimes Department Stores?
So Chimes was started by my grandparents many years ago, and then eventually my parents took it over. And then about 10 years ago, I took it over from them.
And how long have you worked there, Ms. Geller?
My whole career, ever since I graduated from Baylor.
Where's the store located?
It's on Bosque Boulevard, or Avenue, excuse me, which is just on the other side of Waco.
Now, I want to talk a bit more about the location of the store. That space on Bosque Avenue, are you guys leasing it?
We are.
And are you familiar with the lease for that location?
I am.
Geller, I'm showing you what's already in evidence as Exhibit 11. Is this that lease?
It appears to be, yes.
Now, who is the landlord on this lease?
That's Kermit Realty Group, LLC.
And who's the tenant?
That's Chimes Department Stores.
Now we're going to enlarge section 1.10 here. What does this section cover?
This talks about the demised premises for our lease, which is space that's in front of the shopping center, and it's approximately 18,000 square feet of space in the shopping center, and being the space crosshatched on the site plan, which shall have a minimum of 100 feet of clear interior width, according to the lease.
Now, is the demised premises the space that you at Chimes Department Store are actually leasing from the landlord?
No, this is just part of the property that is under our control under the lease, but we're not actually using the space per se.
Sorry, Ms. Geller, just to be clear, did you mean that yes, this is the space that you're leasing and that you control?
Yes, it's part of our lease.
Okay, now this section talks about the crosshatched portions of the site plan. Now, Ms. Geller, I'm going to show you what's already in evidence as Exhibit 12. Is this that site plan?
Yes,
Now I'm outlining an area in blue here. Does this enclose the crosshatched area?
it does.
So is that the demised premises under your lease?
Yes, it is.
Now, is the landing and stairs at issue in this trial today included in this blue area?
No, that's a common space.
And where is that landing and common space located?
So it's marked on this map right here with the red X. It's right behind our store.
Thank you, Ms. Geller. Your Honor, I move to preserve this as demonstrative Exhibit 12A to use in closing arguments.
Any objection?
No objection, Your Honor.
So preserved.
Now, Ms. Geller, because that loading dock, as we just saw, is outside of the blue area, was it under Chimes's control?
No, it never has been.
Did your employees use that area at all?
They did, but it's open for anybody to use.
What do you mean it's open for anybody to use?
So that's a common space that's just part of the department store or a part of the shopping center, excuse me. And then that space is controlled by Kermit. And so anybody's free to use it. If anybody wanted to skateboard or eat a sandwich, we don't really care. But our employees do take breaks out there sometimes and they take stuff to the dumpster.
Now, just to be clear, according to your lease, because this was a common area, who was responsible for maintaining it?
Kermit Realty Group.
And that's your landlord?
That's our landlord, right?
Now, Ms. Geller, I'm showing you section 6.3 of your lease with Kermit Realty. Can you read what this says?
It says maintenance of common area. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area. And landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
And where was the plaintiff when he was injured?
He was on that common area.
Was he on that loading dock that we saw with the red X?
That's right.
So according to your lease, who was responsible for maintaining that area?
Kermit Realty Group was responsible for it.
Now, I want to talk more specifically about the loading dock for a minute. We've heard some claims today from the plaintiff's expert that that back area isn't a loading dock. Now, as the store owner, what was this space behind the store?
So we've always used it as a loading dock. At the beginning of our lease, we did ask Kermit to remove the railing so that we could use it as a loading dock. That's where we get deliveries. Like I said, we sell a little bit of everything. So when we get deliveries for our store, we unload and load trucks back up there. So that is our functional loading dock space.
Now, just to be clear, Ms. Geller, did you remove the railings on that landing or did you ask the landlord to do it?
No, we requested that the landlord do it and they were happy to.
And if that loading dock did have a guardrail, would you still be able to receive all those deliveries that you just told us about?
No, we definitely wouldn't.
And is that loading dock used for any other purposes?
Not by us. Sometimes employees take breaks out there if they need to take a smoke break or something, but not for any official business.
Do you also use it as an area to throw out trash?
We do have a dumpster out there.
And was that area open to be used for other things, should that have been necessary?
Absolutely. Like I said, anybody could access it.
Does that include non-employees?
It does.
Now, Ms. Geller, does your lease indicate who is responsible for loading areas?
Yes, Kermit is as part of the common areas.
I'm showing you section 6.1 of your lease. What's the title of this section?
This says use and regulation of common area.
And can you read this section for us, starting at the beginning through the phrase lighting facilities?
Yes. The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities as such may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls and promenades, enclosed or otherwise, and lighting facilities.
Ms. Geller, do you consider the loading dock at issue here today to be a loading area?
Absolutely.
And do you consider the lighting above that loading area to be a lighting facility?
I do.
And according to this section, who is responsible for the loading area and lighting facilities?
The landlord is.
Finally, Ms. Geller, I want to talk briefly about the plaintiff's conduct. Did Chimes department stores make the plaintiff take a smoke break on January 23rd?
Certainly not.
And did you hear him say earlier that he sometimes, withdrawn, Your Honor, would Chimes have stopped the plaintiff if he went to take a smoke break somewhere else besides the back of the store?
We don't like it when people take smoke breaks in front of the store just because it does make our store look bad, but he's free to go to his car or go further back out or do whatever he pleases, as long as it's not right in front of the store.
And did Chimes force the plaintiff to go around the half open door on the landing when he was coming back inside?
No, I'm not sure why he did that.
Thank you, Ms. Geller. Pass the witness, Your Honor.
Cross.
Yes, Your Honor. Ms. Geller, you work at Chimes Department Store.
I own it, yes.
Right, you've been there since you graduated college back in '98.
That's right.
At first, you started working in the buying department.
That's right.
And like you said, now you're the owner.
That's right.
Have been for the last 10 years.
Yes.
You've already said it, but Chimes isn't just a regular business to you.
I'm not sure what you're referring to, but no.
It's a family business.
Right.
Your granddaddy founded it.
He did.
And he passed it on down to your daddy.
That's right.
And your daddy passed it on down to you.
That's right.
So you take pride in Chimes
Of course I do.
and its image.
Yes.
You do not let your employees smoke out front.
No, we don't.
Right, because that's where customers walk in.
That's right.
And you say it looks trashy.
I just don't think it's a good look for the store.
I'm going to take you back to my question. You said that it's trashy, right?
I don't recall saying that.
Do I need to show you your deposition?
You can.
One moment, Your Honor. We'll come back to it, Your Honor. Now, so you send your employees out back to smoke.
We don't send them to smoke, but they're free to go out back if they'd like.
You've told them they can't smoke in front.
That's right. That's our rule.
But if they want to smoke on the premises, they need to go out back.
That is the only place that they could go, right?
On the premises, right?
They can go off premises if they like to.
And out back is out by your garbage
That's right.
and some other stuff.
I'm not sure what other stuff you're referring to, but the garbage is there.
Got a landing platform out there too.
It's not ours, but we do have access to one.
The landing platform y'all use.
Yes, we use it, and other people are free to use it as well.
All right, so let's talk about this landing platform that everybody can use. When you first rented this space, you asked Kermit Realty to remove the guardrails from around that landing platform.
Right, so that we could use it as a functional loading dock.
Right, and you even asked Kermit Realty to remove the handrails from around the stairs leading up to that platform.
Again, so that we could use it.
And just to use it as a loading dock, you had Kermit Realty line out some concrete for a ramp leading up to that platform.
Right.
So you could use it as a loading dock and trucks could back up to your building.
Yes.
And so you could use it as a loading dock. You paid for those changes.
Yes, it's part of our lease.
But like you said, the landing area really isn't yours.
It's not.
I'm going to show you what's already in evidence as Exhibit 19. See the screen all right, Ms. Geller?
I can see it.
Exhibit 19 is a picture of what the landing looks like after you had Kermit Realty make those changes, right?
That's right.
There's no railings on that landing,
That's right.
no rails on the stairs.
That's correct.
You got some chipped concrete on the edges.
Looks like some chip paint, I think, but yeah.
Chipped paint. Okay. Now you've used that landing for your store since you had those changes made, right?
That's right.
Your store receives deliveries every week.
That's right.
Deliveries are made to that landing every week.
Yes.
Boxes are unloaded to the landing every week.
That's right.
Your employees move those boxes from the landing to inside your store every week.
They and the delivery drivers. Yes.
But you claim the landing area isn't really yours.
It's not. It's part of the common area of the premises.
And you also had your employees do other work in that common area, right?
I'm not sure what work you're referring to.
You did not leave the cleaning of that landing area to Kermit Realty.
Well, we'd like them to make sure that the area around the dumpster is clean, just so that, trash doesn't pile up. But other than that, not really.
So you had your employees clean up the trash around that landing area.
Well, they're the ones that throw the trash out. So just making sure that nothing gets on the ground.
Right. And you also had your employees take the trash out through that landing area.
Right. We did.
Down the stairs.
Yes.
Even had a dumpster placed next to the landing area for your store's trash.
We did.
Now, this is the dumpster you had placed next to the landing area.
Right. But that's part of using it as a common space. That dumpster is not permanent.
Now, we're going to talk about this one on the left. That's the cage. You paid for that dumpster.
The cage?
Yes.
I believe so, yes.
In fact, you did not even ask Kermit Realty if you could put that dumpster there.
I'm sorry, are you referring to the dumpster or the cage?
We'll go with the dumpster since that's what you seem to be talking about. So you didn't ask Kermit Realty if you could put that dumpster there.
No, we didn't, because that's doesn't do anything to their premises.
Right, so you just did it.
Right.
But again, you claim the landing area really isn't yours.
It's not.
You're also required your employees to take their smoke breaks on that landing.
They don't have to take it on the landing. They can go elsewhere, but just not in front of the store.
Right, in the surrounding area in the back of the premises.
Sure.
But you claim the landing area really isn't yours.
It's really not ours.
All right, so let's talk about the lighting on that landing platform. There's a light fixture, right?
Yes, there is.
A light fixture near the landing platform.
Right.
Now, the light was not automatic.
No, it's not.
Had to be turned on by a switch.
That's right.
But your employees could not turn it on.
No, they couldn't.
Right, because the switch was not in your building.
It wasn't.
It was in one of the businesses next to yours,
That's right.
but that switch is now inside your building.
It is now.
That switch controls the light outside that shines down on your loading dock.
Yes.
Now, obviously, you knew that switch was not inside your building before Mr. Gilmore was injured, right?
It wasn't.
You could have put that switch inside your building before Mr. Gilmore was injured, right?
I suppose we could have.
Objection, Your Honor, this is a subsequent remedial measure under 407.
All right, reply.
Your Honor, this is going to feasibility and control. We've heard testimony from Mr. Gilmore that he was told by the agents of this defendant that the reason there was no outside lighting was because they were unable to do anything since the switch was in a different business. And since January 23rd of 2019, this defendant was somehow able to install the switch from the outdoor light, showing both feasibility of the installation and control over that switch.
Why?
Your Honor, feasibility is not something that has been in contention here today. Ms. Geller hasn't said anything as to whether or not it was feasible to put in such a switch. Therefore, feasibility is not an exception under which this can be used. They only said that it hadn't been done, not that it wasn't feasible. As to control, Your Honor, this switch was an entirely new switch. The only thing that Ms. Geller has said is that the previous switch was located in a different place that that the landlord had control over and not Chimes Realty. The fact that a new switch was created is something completely different. It's not something over which Chimes could have executed control prior to that switch being created.
May I respond, Your Honor?
No, sir, not yet. Hadn't we already launched into a discussion of the light switch and its location being in the store of the defendant before any objection was made?
Your Honor, at the time of this accident, that there was a switch located in a different store next door to Chimes department. This switch that we're talking about right now was installed after the accident.
So I believe there was a question asked about that went unobjected and was subsequent to the questioning by plaintiff's counsel for that reason, and that it barely skirts the feasibility. I'm going to overrule your objection. Proceed, counsel.
Yes, Your Honor. I ask you again, Ms. Geller, you could have put the switch inside your building before Mr. Gilmore was injured, right?
Well, the lighting is controlled by Kermit, so it's really up to them where they put the switch. I suppose we could have requested that it be put inside our building, but we hadn't had issues with it up until that time.
I'm sorry, Your Honor. Were you saying something?
Fine.
Yes, Your Honor. I'm going to direct you back to my question, Ms. Geller. You could have put a switch inside your building before Mr. Gilmore was injured, right?
I suppose we could have.
Because you did it after he was injured.
That's right.
And you simply did not.
That's right. We hadn't at that until that point.
Until after he was injured, correct?
Right.
So let's talk about the day Jordan Gilmore was injured. He was injured on January 23rd of 2019.
That's right.
At 7 p.m.
Right.
Now, you would agree with me that it's dark at 7 p.m. in January.
Typically.
So that's a yes?
Yes.
So you would also agree with me that in January of 2019, the door onto the landing area opened towards the stairs.
Yes, I believe that's correct.
In fact, the door opened into the stairs.
Yes.
And blocked the stairs if not opened all the way.
Right.
And of course, on the night Jordan Gilmore was injured, there was no guardrail on the platform.
No, there isn't.
And no guardrail on the stairs.
Right.
Pass the witness, Your Honor.
Redirect.
Yes, Your Honor. Ms. Geller, you were asked about the light switch that you put into the store. Pursuant to the terms of your lease, was that light in a common area?
Yes, it is.
So was it your responsibility to maintain how that light was turned on and off?
No, it was not.
And what about that loading dock? Was that in a common area?
Yes.
So was it your responsibility to maintain the safety of that loading dock?
It was not.
Whose responsibility was it to maintain that light and that loading dock?
Both of those things were under the control of Kermit Realty.
Thank you, Ms. Geller. No further questions, Your Honor.
Anything further of this witness?
No, Your Honor.
Hearing none, this witness is excused. Call your next witness.
Your Honor, at this time, the defense will be calling Perry Hayden by deposition. Your Honor, we will be constructively moving in the entirety of Perry Hayden's deposition with the exception of a few portions that I will highlight now. They are pages 11, lines 4 through 15, and pursuant to our pretrial conference with opposing counsel, page 7, line 20 to page 8, line 19. And Your Honor, at this time, I will be reading the questions and my second seat, Ms. Goja, will be reading the answers so that the jury may hear certain portions highlighted from the deposition.
Proceed.
Beginning on page 2, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Moving to line 11. What do you do for a living?
I am a compliance safety and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there.
Moving now to line 22. And what do you do at OSHA as a compliance safety and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
What happens if a workplace doesn't comply with those OSHA standards?
Well, there are lots of potential implications, but at the very least, it would result in a citation for any violations that we find.
Moving now to line 16. How long have you worked for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
Moving now to page 4, line 14. How did you end up being involved in this case?
I got a subpoena from you and it told me to show up here. So that's what I did.
Moving to page 5, line 1. Are you being paid by anyone for your time here today?
Nope.
Have you been retained by anyone to serve as an expert in this case?
Nope.
All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018.
Moving to line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection.
And moving to line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
How did you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Moving now to line 22. When you went out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs in a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
If there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
because OSHA said so.
Moving now to page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Moving now to page 9, line 3. Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
I'm sure Ms. Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No, it is my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Your Honor, this concludes the portions we'd like to highlight for the jury. And at this time, we would constructively read Code Section 1910.28B13 from OSHA pursuant to the portions that we just read from Perry Hayden.
Any objection?
No objection to this, Your Honor. However, I'm going to want to read that portion of OSHA out loud after my cross-examination.
All right. Anything further, defense?
Nothing further from this witness, Your Honor.
All right, proceed, plaintiff.
Yes, Your Honor. Citing court and opposing counsel to page 10, line 3 through page 11, line 3. Question: is Exhibit 38 a true and correct copy of that email?
Yes, it is.
Do you disagree with the assessment of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible, but I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Ms. Hayden, I'm showing you what has been marked as Exhibit 39. Do you recognize this?
Yes, this is the email that I sent back to my supervisor in response to that previous email.
Is Exhibit 39 a true and correct copy of that email?
Yes, it is.
What was the result of the performance review referenced in these emails?
I got a pretty typical review. I think I was rated adequate, and I still have my job. So I guess whatever problems they had with my work weren't a big enough deal to fire me.
Citing court and opposing counsel to page 11 at line 16 through page 12 at line 5. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Did you have them turn it on for you while you were there?
No, didn't seem necessary.
At this time, Your Honor, permission to constructively publish Exhibits 38 and 39 as they were referenced in the selected portions of the deposition.
Any objection?
I'm sorry, I couldn't hear you, opposing counsel. Can you please repeat that?
Permission to constructively screen share Exhibits 38 and 39 to publish to the jury, but not to go back to them.
Your Honor, I'm a little confused as to why opposing counsel would show the jury exhibits that they're not intending to offer into evidence. And Your Honor, I believe there are some hearsay issues as to any statements by Ms. Hayden's employer contained in these emails. As such, I would object to the jury seeing them.
Sustained.
This time, Your Honor, permission to screen share OSHA 1910.28B1 subpart 3 to be read in.
Any objection?
No objection, Your Honor.
You may proceed, Mr. Banks.
Yes, Your Honor. Subpart 3. When the employer can demonstrate that the use of fall protection systems is not feasible on the working side of a platform used at a loading rack, loading dock, or teaming platform, the work may be done without a fall protection system provided. The work operation for which fall protection is infeasible is in process. Access to the platform is limited to authorized employees, and the authorized employees are trained in accordance with section 1910.30. Permission to preserve this as defense or as plaintiff's demonstrative A.
Defense?
No objection, Your Honor.
So preserved.
Pass the witness, Your Honor.
Anything further from the defense?
Your Honor, we have nothing further from this witness, and with that, the defense rests.
All right. Anything from the plaintiff?
No, Your Honor, just request a recess at this point.
Let's take a 5-minute recess, and then we will proceed to closing arguments.
Yes, Your Honor.
Your Honor, before we break, would you prefer that we renew our motion now or after our break?
It's
Before closing argument?
denied.
Yes, Your Honor.
All right, that's 5 minutes, please.
Yes, Your
Thank
Honor.
you. Council, do we have any matters that haven't already been dealt with prior to commencement of closing argument?
Not for the plaintiff, Your Honor.
None from the defense, Your Honor.
By my calculations, plaintiff has 15 minutes remaining. Defense has 22 minutes remaining.
Put me a timer at 12.
Is that any perceived issue, plaintiff?
No, Your Honor.
Any perceived issue, defense?
No, Your Honor.
I would hope not, frankly, for both of you. For plaintiff, do you want any warning?
Yes, Your Honor. At 2.5 minutes remaining.
Okay. All right.
Thank you, Your Honor.
And how about for defense?
Your Honor, I won't be needing any warnings. Thank you.
Okay. All right.
And Your Honor, can I reserve the remainder of my time for rebuttal?
Well, okay. Are you saying that 2.5 minutes for rebuttal?
Yes, Your Honor.
Okay. Well, counsel, I'm going to do it at 13. I'm not going to worry too much. I don't think defense counsel is going to be too upset with that, giving you three minutes or so. All right. With that, having brought back the jury for closing argument, plaintiff, you may proceed.
May it please the court. Some people want all the control and none of the responsibility. This defendant wanted all the control over the landing area behind their store. They wanted their employees to keep it clean, to pick up the trash on it, to unload merchandise on it, to load merchandise on it, to use it to take the trash out of the store to the dumpster right beside it, to send employees outside to smoke on it. They wanted all of the control over the loading dock, but none of the responsibilities that came with that control. Members of the jury, you are here today because Jordan Gilmore was injured. Because he was injured due to the negligence of this defendant, Chimes Department Store, because Jordan Gilmore was injured, we have brought a negligence claim against the defendant. When we brought this claim, we took on the burden of proving to you that it is more likely than not that the condition of Chimes Department Store caused Jordan Gilmore's injuries. In order to meet our burden using the evidence, we had to prove to you three things. One, that the loading dock area of Chimes Department Store posed an unreasonable risk of harm. Two, that Chimes Department Stores knew or reasonably should have known of that danger. And three, that Chimes Department Store failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. We have met our burden today. So let's talk about how we met that burden. Kelly Danes told you that the defendant failed to comply with the International Building Code and OSHA standards for guardrails. First, over 30 inches must have guardrails. This platform was 34 inches with no guardrail. Second, responsible for maintaining and free from recognized hazards. Look at the condition of this landing and these stairs. Not only are there no guardrails, but the concrete is crumbling. Jagged edges, doors swinging out over the stairs. All easily recognized hazards. Third, responsible for making sure there is adequate exterior lighting. Any means of egress or travel is to be illuminated at all times when the building is occupied. In other words, if folks are inside that building, any exit has to be well lit. Now, the defendant had a light outside on that landing, right above it, but it was never turned on. And it was never turned on that night. See, the defendant has tried to throw that off on Kermit Realty, but after this incident, they had a switch to control that light installed inside their building. Somehow, it was feasible for them to have controlled that light before Mr. Gilmore fell. They just chose not to. Even though we had Miss Daines tell you the legal reasons why this landing was unreasonably dangerous, we don't need an expert to tell us that this landing with its crumbling concrete, no guardrails, and in the pitch black dark is unreasonably dangerous. It's common sense. But when we show Miss Geller, the boss lady, this picture, she got up here and told us that all she saw was some chipped paint, not some crumbled concrete, not broken off post. We learned today that the defendant has been in this building for 15 years and that the defendant had the guardrails that were previously on the landing area removed. We have proven that the defendant knew the landing area was unreasonably dangerous. We've also proven that the defendant failed to exercise ordinary care by failing to adequately warn Mr. Gilmore of the condition and failing to make the landing reasonably safe. We've seen all the pictures of that landing and the door leading to that landing. What we did not see in any of those photos, no warning signs, no sign saying watch your step, no sign saying danger, no sign saying caution.
Objection. Your Honor, I'm sorry to object in closing arguments, but this assumes facts, not in evidence. There were no questions
I
about.
believe that's what he's saying, that there wasn't any evidence of it. Overruled. Proceed.
No warning signs at all. We also know that the defendant did not do anything to make the landing reasonably safe. After tearing down the guardrails from 15 years earlier, the defendant did nothing to make that landing safer. In fact, we learned today that after Mr. Gilmore fell and went back inside the store, the defendant's store manager told Mr. Gilmore that she had warned the defendant about the stairs in the past, but the defendant never repaired the stairs. They always had some bigger problem to fix first. Which brings me to the last thing that the evidence has shown you today. The defendant exercised control over the landing. Now, Judge O'Neill will tell you that the defendant, to be liable, must have had control over the area, and that a tenant, like the defendant, is responsible for areas it leases and those areas right next to the leased area that it actually controls. So how do we prove that control? Well, the judge will tell you that control can be proven by an actual exercise of control. We learned today that the defendant exercised control over the area from the very beginning. First, the defendant instructed Kermit Realty to remove the guardrails to build a concrete drive up to the landing. Then the defendant turns around and pays for those changes. That's control. Next, the defendant used the landing as a loading dock. The defendant admitted that they had trucks making deliveries to the store and using that landing every week. That's control. Next, the defendant put in a separate dumpster right next to the landing without ever asking Kermit if they could. Control. The defendant required their employees to use the landing to take the trash out. Control. The defendant required their employees to clean the landing and surrounding area. Control. The defendant required their employees to smoke outside on the landing and in the surrounding area. Control. The defendant exercised control over the landing area, and their negligence was the proximate cause of Jordan Gilmore's injury. The judge will tell you that the proximate cause is the substantial factor in bringing about what an injury, and that without that cause, that injury would not have occurred. Without the defendant having an unreasonably dangerous landing, this injury does not occur. The complete disrepair and lack of guardrails on the landing was the substantial factor in Jordan Gilmore's injury. And it was absolutely foreseeable that someone could and would fall off that landing or off those stairs. The defendant was negligent. And the defendant's negligence caused Jordan Gilmore's injury. Of course, today the defendant has tried to convince you that Kermit Realty was in control because of the language of some long lease. Now, the lease might have given Kermit some control, but as we've already discussed, exercising control over the landing also establishes and proves control, and that there is no question that the defendant exercised control. And in fact, through their behavior, despite what Ms. Gaylor tried to tell us today, demanding Kermit change the landing area to the defendant's specs and then paying for those changes, proves that the defendant exercised more control over the landing area than Kermit Realty ever did. This defendant has tried to blame Jordan Gilmore for his own injuries. We told you from the beginning that when Mr. Gilmore felt his foot slipping, he jumped to avoid falling over. But Mr. Gilmore would have never been in the position where he needed to jump if the defendant had not removed the railings from the stairs to begin with. Maybe, just maybe, Mr. Gilmore never even slips if the defendant had not failed to adequately light the landing area to begin with. Mr. Gilmore would not have even been outside on the landing if the defendant didn't make him go out there to smoke on breaks to begin with. The defendant can try to blame Mr. Gilmore all they want, but the responsibilities for Mr. Gilmore's injuries begins and ends with this defendant, Chimes Department Store. Some people want all the control, none of the responsibility. This defendant wanted all the control over the loading dock behind their store. This defendant took all the control of the landing area, but they wanted none of the responsibility that came with that control. The judge will give you this verdict form. When you go back to start deliberating, first question you'll see is, did the negligence, if any, of those named below proximately cause the occurrence or injury in question? For Jordan Gilmore and Kermit Realty, the answer is no. For the defendant, the answer is yes. If that is how you answer, you don't even have to go to the second question. But if you answer yes to either Jordan Gilmore and or Kermit Realty, you will then assign a percentage of responsibility to each person. Now, because the defendant exercised control over the landing area, assign to this defendant at least 90% and assign the rest to Mr. Gilmore or Kermit Realty. The defendant is responsible for the unreasonably dangerous condition of the landing area and responsible for the injuries Jordan Gilmore suffered. Find the defendant responsible.
Defense,
Yes, Your Honor. May I just have a brief moment to prepare?
brief.
May I proceed, Your Honor?
You may.
Members of the jury, at the beginning of this trial, I told you that by this point, you would know three things. First, that the common area outside of Chimes department store was not controlled by Chimes, but by Kermit Realty. Second, that the area from which the plaintiff fell is a loading dock, and therefore the regulations you heard about today do not apply. And third, that it was the plaintiff's own choices, not anything that Chimes department stores did, that actually caused his injuries. Chimes did not control that common area, and they did not control the plaintiff's choices. Without control, there is no responsibility, and there can be no liability. Members of the jury, today the evidence has shown that the plaintiff's choices put him on that loading dock. They led to his injuries, and now he's come here today to try to place responsibility on the wrong people. Now let's talk about what you learned today. Now, the first thing that the plaintiff had to prove is that it was more likely than not that Chimes department stores controlled this loading dock. Every time the plaintiff has talked about it, they've made it the last thing that they have to prove, but members of the jury, it's first. Because if Chimes doesn't control that loading dock, then this case is over. Without control, there's no obligation to keep that loading dock safe. And today the plaintiff did not prove at all, much less by a preponderance of the evidence, that Chimes controlled and was responsible for that loading dock. All they did was tell you that Chimes uses the loading dock, both to accept deliveries and to throw out trash and for employees to take their breaks. But members of the jury, those are all examples of use, and use alone does not equal control. This was a common area that any tenant in the building, any number of the businesses in this strip mall could have used in any way that they like. The fact that Chimes used it as a loading dock does not mean that they were responsible for maintaining it. And I want to clarify something that the plaintiff said in his closing, because he said that Chimes instructed the landlord to remove the guardrails and to pave the street. And that's not correct. What actually happened is that Chimes asked the landlord if those guardrails could be removed so that they, as the tenant, could use it as a loading dock, and the landlord obliged. That's very different than Chimes demanding from the landlord, the actual owner of the property, that that space be changed in any way. It was a request that was made on behalf of a tenant and granted on behalf of the landlord, who actually executed control. All they did to try to prove otherwise was claim somehow that use equals control, but members of the jury, that is not enough. Now, we, on the other hand, brought you Reese Geller, who discussed the terms of the lease that Chimes has with Kermit Realty. And in that lease, it specifically says that common areas are the responsibility of the landlord. So anything that happens in those areas, anything that may or may not make them unsafe, those fell squarely on the shoulders of Kermit Realty, LLC. Chimes department stores had nothing to do with them. And then you also heard that the lighting outside and that anything that was going on in that area was specifically to be maintained by whoever controlled the common area. That again was Kermit Realty, LLC. So the person who had the responsibility, the person who had the control, it's right here in black and white in the lease. It's the landlord. It's not the tenant. It was Kermit Realty, LLC. It wasn't Chimes department stores. And members of the jury, right then and there, this case is over. We don't have to go any further, because if they can't prove control, there's no responsibility and there can be no liability. But nonetheless, the plaintiff also has not proven that there was actually anything wrong with the way that area was maintained. They brought you the report of Kelly Danes, a paid mechanical engineer, was paid for the opinions that you heard today. And what did those opinions actually say? They said that Chimes violated OSHA and IBC regulations, but members of the jury, you heard that that wasn't actually true, because these regulations, they don't apply to loading docks. And as the evidence clearly shows, that's what this platform was. You heard on closing about IBC section 1012.1. But if you look at the words of that statute, members of the jury, it specifically says that loading docks are not subject to this requirement. So there were no requirements that you heard today that there be railings on that platform or on those stairs. Because pursuant to the request from Chimes Realty, when they moved into that space was converted to a loading dock, and they've used it as such consistently for the past 20 years. Now, members of the jury, we brought you the report of Perry Haynes, an actual OSHA investigator. Now, Perry Haynes' entire career is to know and understand OSHA regulations so that she can investigate workplaces and determine whether or not those workplaces are up to code. And you heard that in 2018, Perry Haynes investigated the Chimes department store. She saw everything that the plaintiff claims made that area so dangerous. She saw the conditions of the concrete. She saw that there were no railings on the landing. She saw there were no railings on the stairs. And she issued no citations whatsoever. The actual trained, unpaid governmental officer who reviewed this work site years before any litigation was commenced determined that there was nothing wrong with it. In response to this, the plaintiff has tried to undermine her credibility. But members of the jury, the fact that she had a performance review at work doesn't matter. It happens to everybody, and she still has her job. So if she should have been issuing citations that she failed to issue, the government would have taken action, and she wouldn't have a job anymore, much less be offering a report for you to hear here in court today. And let's not forget which party here today had a paid expert give opinions that have no actual factual foundation, and who brought an OSHA investigator, an impartial governmental agency officer with no dog in this fight, just to report what they found. That was us. That was not the plaintiff. Members of the jury, the evidence has shown that Chimes department stores did not actually violate any regulations. Those regulations applied to loading docks, and those regulations had nothing to do with the space where the plaintiff was injured. And that space, as it is abundantly clear, was not under the control of Chimes department stores. No control, no responsibility, and no violations proven anyway. Chimes had no control over this area. They had no responsibility for how that area was maintained, so they cannot be held liable for the plaintiff's injuries. Members of the jury, Chimes also didn't control the plaintiff's own choices. Because on January 23rd, 2019, the plaintiff chose to put himself in a position that resulted in him being injured. Now, we understand that when someone gets hurt, when someone's in an accident, they want to hold somebody responsible. It's natural. It makes sense. And we're not saying that Mr. Gilmore is anything other than a good man who was unfortunately involved in an accident. We're sure that he is. But the truth, members of the jury, that you have to consider here today is that Mr. Gilmore failed to act as a person of ordinary prudence would in his position, and that is what caused his injuries. Chimes department stores had nothing to do with it. And the truth is that on January 23rd, 2019, the plaintiff chose to go out back and take a smoke break. It was 7 p.m. in the middle of the winter. It was dark. It was freezing. It was windy. The plaintiff could have gone and taken a smoke break in his car, or he could have gone off the premises, but he chose not to. He chose to go out in the back. He went down those stairs, he smoked a cigarette, and then when he came back up those stairs, he saw that that door was propped half open, blocking most of the landing that he had to walk up to get back into the store. Now, at that point, the plaintiff could have chosen to have that door opened all the way. You heard his coworker, Riley, was standing right there. She could have pushed the door open all the way if the plaintiff had asked. She could have moved out of the way so the plaintiff had more room on the landing. The plaintiff could have asked her to close the door all the way. You saw all those pictures that show just how much space the plaintiff would have had if he'd made any of those choices. Unfortunately, he didn't. Instead, he chose to go up onto the landing and scoot around the tiny bit of space that was available between the edge of the door and the edge of the landing. And you heard the plaintiff has been on that landing tons of times before, at least 20 times a week. He knew the conditions. He knew that there was no guardrail. He knew what could happen if he slipped. He chose not to do anything to make that safer. And unfortunately, members of the jury, the reality is that that choice is what led to his injuries. Chimes Department Store had no control over those choices, so Chimes Department Store bears no responsibility for the consequences. Members of the jury, our hearts go out to Mr. Gilmore. We're sure he's endured immense hardships as a result of his injuries. But here today, he has not proven by a preponderance of the evidence that Chimes Department Stores is responsible for those injuries. Just because you want to hold somebody responsible does not give you license to place responsibility on the wrong party. And the evidence has shown that Kermit Realty LLC, the landlord, was responsible for that area, and that the plaintiff was responsible for his own choices. They had control. They bore responsibility. So if anybody is to bear any liability, it should be them. As such, members of the jury, when you get to question 1 on the jury sheet, you can look at the evidence you've seen and the testimony you've heard and answer no for Chimes Department Stores Incorporated and yes for Jordan Gilmore. Now, as for Kermit Realty Group LLC, I suggest that you answer no, because as we've discussed, the plaintiff has not proven that Kermit Realty actually did anything wrong in the way they maintained that landing. However, regardless of how you answer for Kermit Realty LLC, when you get to question 2 on the jury sheet that asks you to apportion percentages of responsibility, you can look at the facts and the evidence and assign 0% liability to Chimes Department Stores and find them not liable. Thank you.
Rebuttal,
A moment to set up, Your Honor.
you have that. You do have 3 minutes.
Yes, Your Honor. The Occupational Safety and Health Administration, same agency that employs the defense's expert, government entity that institutes regulations for employers, just like the defendant Chimes to follow to make sure that they keep their employees safe. And the second thing out of defense counsel's mouth when she just stood up was about a loading dock. So let's talk about what employers have a duty with relation to a loading dock. See, 1910, 28B3, B13, when the employer can demonstrate that the use of fall protection systems is not feasible on the working side of a platform used as a loading dock, the work may be done without a fall protection system provided. The work operation for which the fall protection is infeasible is in process. No evidence today came out, not from the defense's witnesses and definitely not from ours, that Mr. Gilmore was acting within the scope of a loading dock. So there should have been temporary rails based on that alone. Now we go to B. Access to the platform is limited to authorized employees. Now, what did Ms. Geller get up here and tell us? That anybody could have got up there. A kid on a skateboard, some random person eating their lunch as a sandwich. Now, those are not authorized employees. So the use of that loading dock was not limited as it's required by OSHA. And lastly, the authorized employees are trained in accordance with 1910.30. Nothing from the boss lady herself spoke on her training of her own employees in relation to this. And again, fails to meet the OSHA regulation. So despite, and even given the defense that this was a loading dock, they still did not live up to the statute they want to quote and that their expert quoted, just not in its entirety. But instead, what they try to focus on is a lack of control because their lease agreement says it's all on Kermit. But it also was Kermit's responsibility under that lease to fix the light.
Yeah,
They
1
up,
minute, counsel.
they up and did it anyway. It wasn't the defendant's areas out back, but they threw a dumpster there anyway. But now when it comes to some guardrails and some chipped concrete, it's very casually not their responsibility. That was all on Kermit. We're not the ones trying to bring Kermit into this lawsuit. We came after this defendant alone. It is this defendant who's trying to scapegoat, shift it onto their landlord, but tell you that they had no part in it today when they were filling out that verdict form. Again, as they have the whole process, they are shifting responsibility. Make the defendant responsible. Fine for Jordan Gilmore.
With that, same will be submitted to the jury, and we will await their verdict. Thank you all. If you can go ahead and I guess stop video and mute while our judges, scoring judges undertake their duties and responsibilities, and we will come back once that is done and completed. Well, while we're waiting for confirmation from our administrators that they've received scores, I'll briefly make my comments. First and foremost, again, I really want to congratulate y'all, and I want to make the bar extremely hard so that none of y'all can pass it, and I don't have to face any of y'all down the road. Very, very, very talented group, and you're to be commended. From the plaintiff, the idea that we want to make very short and pointed comments that may assist you in the following rounds. You wanted to publish a document, the email to the jury that had not been admitted into evidence. Ain't ever going to happen. I think both of you had good theories, but the reliance of the defense, and I'm an insurance defense lawyer, so just give you that. But the reality is we rely on the OSHA and whatever standards when we can. And what you want to say, and especially you're in Texas, it's like the government has these rules. Give me a break, and that's where you came back and strong with common sense. And then when counsel for defense, you got to be careful. You said that there was nothing wrong with the conditions as testified to by your expert. She most assuredly said there were problems with the conditions. She just took a hyper-technical approach. I do this now moving to the defense, because again, we're trying to keep it short and to the point. But I do this all the time. And I had the very judge of this court tell me, seriously, Colin, was that no to my question correct? Okay, the jury is like going, okay, what are you saying? So be careful about that. Then I also, there's a matter, and you kind of went around it, but again, being an insurance defense lawyer, the condition was open and obvious. He'd been up and down those stairs a whole bunch. You talked about it without ever just specifically speaking to it. I find it last comment I have, it's very dangerous to say our hearts go out to the plaintiff, because the plaintiff's lawyer is going, I don't need Mr. O'Neill's heart. I need his money, and I need his client's money. You got to be careful about that. All right, other comments? Travis, you want to? I'm not
I can't hear you.
Yeah, we're not hearing you. You went off mute, but yeah. We're good? Okay. Well, we have all scores, so we're good. We just need the comments. Let's jump to James while Travis figures. It may be your mic isn't up all the way. James? Jim?
Travis, it could also be which mic input you're selected under the little caret under your mute button, but I'll be really, really brief. So Mr. Banks, I love your colloquial style. Just be sure you don't take it too far on a couple of things. So the ones I wrote down were, Jordan, turn your camera on and say, hey, that's too far for me. And boss lady, that's too far for me. I think being able to relate to a jury and get them to like you and see you as a real person, that's all great, but there's too far. And in my judgment, those were the two that went too far. So they told us to give you the things that we thought would really help you in future rounds that might alienate somebody. And then Miss McGuigan, I thought your tone on cross was really good. And I love good, short, fair questions. The tricky thing about short questions is you got to sell them a little bit with your tone to make sure they land, because they're so short. There's not a lot of content there. And that's kind of how I do it too. I build it a brick at a time. But now you got to sell the emotional content and import and focus of it with your tone. And that's very important when it's a short question, and you're pacing and let it sit. And you're doing a great job, because he can't argue with it because you just asked the one thing. But it's so quick and so short that it might slipped by them as to the import of what you said. But you guys both did a great job. Really enjoyed it.
Jennifer?
I'll make mine that goes for, well, I'll start with Mr. Banks. Nobody wants to have to read a deposition into evidence, but it was clear that you didn't want to have to read it into evidence either. So we felt that. It's not exciting testimony, and there's only so much you can do, especially via Zoom, but as much energy as you can put in the line and as much as you can not read off the paper, attempt to do so. Because if it's hard for you to even have to read it, it's very hard for your jury to have to listen to it. It was not unique, but it's a way to set yourself apart. Defense, I would say just always watch your facial expressions, especially sitting on Zoom. I've been coached on that many times. I'm overly expressive when I agree with something and when I disagree with something. You didn't have any inappropriate facial expressions by any means, but you did look a little bit bored or a little bit put out at times. I don't think you were, but your jury watches the craziest little things like that, and are especially hard on, well, we have to watch ourselves. Yeah. So that's it. But great job to both of you.
Thank you.
And I'll just be brief. I thought you were both great. Sorry, I'm sitting on my front porch if you hear cars driving by. But I thought you both did an awesome job. You know, I'll echo the comment about the facial expressions, some with the tone of the voice too. As a female attorney, I often get that critique. It's, you know, sometimes it's unfair, but, you know, practice inflecting your voice and making yourself personable, because sometimes it just doesn't read well via Zoom. And then for Mr. Banks, the one comment I had was I probably would not have done that in opening, is make my client turn on the mic. I think it interrupted your flow. So maybe consider that going forward, but you both did a great job.
All right. Well, Travis, you got it worked out? Nope. Still can't hear you, my friend. Sorry. Don't worry. I went
to law school with Travis. Let me say, this may be the first time I've ever heard him silent.
Well, if you want to just put it in the chat, your couple thoughts, and then that way they'll have that for consideration. And then other than that, again, just outstanding job. Greatly appreciate the time and effort of you folks, and greatly appreciate the time and effort of our judges. So with that, thank you.
Thank you.
Thank you, Your Honor. Thank you, everyone. Good luck, guys.
Thank you. I guess Judge is going to come up here.
No idea.
Mr. Banks, what could I help you with?
Oh, no, sir. I was just reading the comment that.
Oh, okay, great, good. So that you have that. Okay, great.
Thank
Take
you.
care.
Thank you.
Thomas Cunningham.
Can you hear me okay?
Just barely. You're there. You seem to be going a little more steady now.
Great. I'm glad I'm off camera for this. I have really bad internet connection due to storms, so I'm going to try to be as out of the picture as I can. I can hear you guys perfectly.
Okay, and I'll put my cell phone number again in the chat once we get a couple more people in here.
Great. Do you say you're the current clerk in the Western District?
Yes, ma'am, I am.
Awesome, wonderful. I worked, did an externship in the DA's office there. So, and for Judge Mansky.
Yeah, that's.
Okay, cool, great, yeah. I was on one of his mock trial teams 1 million years ago.
Understood. Yeah, but it's my second year, and then my wife is gonna actually take over my post. So
that's awesome.
Yeah, very exciting.
Very cool.
All right, Ms. Cunningham. Well, we appreciate you being here, and if you need anything, just text me. Okay. Hi, Mr. Kent. Oh,
close out of all my distracting emails.
Thomas Metz.
Hi, how are you?
I'm good. Do you see my cell phone number there in the chat, or do I need to send that again? I'm planning to send it again.
Let me pull up the chat. Sorry, yes, I don't have it.
Yeah,
I don't
no
see
worries.
it in the chat.
No worries. I should have waited.
I'll write it down right now as well.
There it is. And if y'all have any problems, I'm going to send it a few times while we're admitting people. So feel free to holler if y'all get kicked out. Okay, it looks like we got second chair for plaintiffs counsel in here.
supposed to change my name.
All right, Ms. McGuigan. McGuigan, am I saying that right? Did I guess that right or no?
I'm sorry, I just joined the audio. Were you trying to pronounce my last name?
I was probably wrong, so you just want to tell me how to say it?
McGuigan, Your Honor.
Oh, I got it right. Okay. I'm going to put my cell phone number again in the chat just because y'all don't get it until you show up. So there it is. And other judges, if you're welcome at this time to turn your cameras off, and we'll get started as soon as everyone's here. And I see your second chair's here, Carolyn. So
She is, Your Honor.
hi there. All right. So we're just waiting on defense counsel and then we'll get trucking. And Mr. Kent and Ms. Cunningham, if y'all want, you're welcome to leave your cameras on and visit, but if you don't want to, you don't have to. We'll just get started as soon as they're all here. It's up to you. I'm happy to see y'all, but it's your choice.
I'll stop the turn off camera once we get started.
Okay. All right, now we've got Mr. Ayers just joined us. Yeah, we're just waiting on one more. All right, Mr. Ayers, and then your second chair, Ms. Campbell, do you know where she's at?
She's just coming, Your Honor.
Okay, excellent. And then I'll send my cell phone number out one last time, make sure everybody got it. And if y'all get disconnected or need anything, y'all feel free to text me.
Thank you, Your Honor.
Of course.
Hey, would you mind letting me in? I'm stuck in the weight room. Please, unless I got the wrong one.
There's 2 witness videos for this one room.
Well, we have to have ours on as well. Let me.
Yeah, I'm not seeing anybody waiting in a waiting room in mine.
Let me see.
Let's see.
Yeah, I remember we just switched on this one computer. I was in your room last time for the morning one, but I don't know how other people did it.
Yeah, I don't either. I can certainly go ask, but there's nobody in a waiting room on my end. So, and we're still just waiting on Regina Campbell. Do you want to reach out to your second chair?
We'll get it settled on this end.
It's okay. You want me to go ask or? Okay. Give me 1 second to see if I need to have another witness in the room. Hold on.
Hey, Jack, could you send me the Zoom link in an email, please?
Yeah, I can absolutely do that.
Thank you.
Okay, so witnesses, to clarify, it's just the one room, so there's not going to be anybody else. Okay,
sounds good.
And there's Regina. And then now that we got Regina in here, here's my cell phone number one last time. If y'all need something, let me know. And then with that, if we've got everybody appropriately ready, we can start with the 5 minutes of pretrial for each side. So let me get my timer up real quick. And Judge Ken, when you get a second, if you can turn your camera off for us, because we're going to start the round. Thank you. All right, so plaintiff, whenever you're ready with your 5 minutes of pretrial stuff.
Yes,
Oh,
good.
wait, I can call the case. You want me to call the case? Got the name of it somewhere. Okay, now calling the case of Jordan Gilmore versus Chimes Department Store. Plaintiff ready to proceed?
We are, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Awesome. Okay. 5 minutes of pretrial for each side. Plaintiff, you can go first.
Yes, good afternoon, Your Honor. My name is Carolyn McGuigan, and I am representing the plaintiff here today, Jordan Gilmore. And I am joined by my co-counsel, Ms. Jahet Gogia. Your Honor, we have several housekeeping matters to go over before we begin our trial today.
Sure.
Met with opposing counsel prior to this trial, and we have agreed to pre-admit several exhibits.
All right.
Those are exhibits numbered 1, 3,
okay,
11,
Mhm.
13, 14, 19, and 22.
Awesome. And I'll just let y'all both know right now, I don't need you to ask to publish those. Just put them up if you want. So second chairs, if you hear that, you don't have to ask, or they don't wait for them to ask if you know when to go.
Yes, Your Honor. Additionally, we will both be offering portions of depositions from expert witnesses that are unavailable today pursuant to Federal Rule of Evidence 804.
Okay.
We have met and exchanged those portions with opposing counsel, and I just wanted to notify Your Honor that we have notified each other of what we will be reading in.
Perfect.
Finally, Your Honor, we are in our current location in the middle of some inclement weather, and the thunder can be rather loud. So if we do have any background noise or any connectivity issues, we just ask for the court's patience.
Yeah, I'll just ask that you stop the thunder from happening. I mean, I think that's the minimum.
My best.
All right.
And then, Your Honor, we had intended to make a motion in limine to preclude Exhibit 37. However, we have agreed pre-trial that there will be no mention and Exhibit 37 will not be entered into evidence here today.
Sounds perfect to me. So no 37. Anything else from plaintiff?
Our housekeeping matters, Your Honor.
Excellent. All right. So let's see. All right. Counsel for defense, any pretrial matters?
May we make appearances for the record first, Your Honor?
Absolutely.
Good afternoon. My name is Jack Ayers, appearing on behalf of the defendant, Chimes Department Store. I'm joined by co-counsel today, Regina Campbell. She'll be handling all the technology.
Thomas Campbell.
We also have one housekeeping matter. I wanted to alert the court that the parties have met and conferred regarding the various versions of the jury instructions, and the operative set of jury instructions will be those that begin on page 33.
Awesome. Okay.
And we have additionally one substantive stipulation. We were able to meet and confer with opposing counsel before trial, and we've agreed to the inadmissibility of any evidence relating to the firing of Jordan Gilmore. The fact that she no longer works for the defendant is absolutely admissible, but the fact that she was fired won't be brought up by either party today.
Got it. Okay. Anything else?
Nothing further from the defense, Your Honor. We're ready to proceed.
Awesome. Okay. So give me just 1 sec to get 55 minutes on the clock. So the way we'll do this is I'll let you know after each time that you talk, how much time you got left. Do y'all want me, when you get down to 10 minutes, you want me to start putting my fingers up so you can watch it? If we get down to 10 minutes, do y'all want that? 10, 9, 8, yes or no? You care?
Your Honor, I think I will, should I get down to 5 minutes and below, I might ask for some.
Okay, I'll do 5. Good.
That sounds good for the defense as well.
Okay. And so then the way it's going to go is just, as soon as you start talking, I'm going to start doing the timer. So whenever you're ready, plaintiff, for opening statement, we're ready to proceed.
Your Honor, may I just have a brief moment to set up before we begin?
Of course, yeah.
And apologies for the interruption. Just to clarify, the clock stopped for objections and legal arguments.
That's right. That's right. Yeah.
Perfect. Thank
And
you.
I'll announce that the clock is stopped, just that way everyone's keeping me honest.
Thank you, Your Honor.
Yes, sir.
May I proceed, Your Honor?
You absolutely may.
It's a dark, cold, windy night in January. An employee finishes their cigarette and heads back up the stairs to return to work. They climb the stairs, and when they get to the top, they're forced to maneuver around the massive half-open door. They slip. They reach out for something to grab onto, but there's nothing there. No guardrails, no handrails. Nothing to prevent him from falling onto the ground below. Members of the jury, that employee is Jordan Gilmore, and that fall and the resulting injury are what bring us here today. The defendant, Chimes Department Stores, failed their employees. They failed to provide lighting, they failed to provide protective railings, and they failed to provide warnings and training. Their failures, their fault for the consequences. You see, in January of 2019, Jordan was working for the defendant at their store as a cashier. And part of his responsibilities included using those back stairs to throw out garbage, something the defendant directed him to do practically every day, something the defendant directed all of their employees to do all the time. And not only that, but you'll learn the defendant told their employees to use those stairs and that back area to take breaks during the workday. And those directions, they led to Jordan using those stairs 20 times in a given work week. And you'll learn that because of those directions, the defendant had a responsibility to use ordinary care to keep those stairs safe. They were the employer directing their employees to use those stairs while they worked. So they had a basic obligation to protect their employees from unreasonable dangers while they used those stairs. And today we will show you the defendant failed. Not once, not twice, but over and over again. Failure after failure after failure. Today you'll hear from a report by Kelly Danes, an expert mechanical engineer who will explain to you how the defendant was responsible for keeping that area reasonably safe. And then she'll walk you through the specific ways the defendant was required to and failed to keep that area safe. Particularly, she'll discuss regulations with you that said that the defendant had to provide adequate lighting in that area so that employees could see where they were going as they went up and down the stairs. She'll discuss regulations that required the defendant to provide safety railings on those stairs so that employees had something to hang on to and something to protect them from falling over the edge should they slip. And she'll discuss regulations that say that when that massive door was open, there had to be enough space for employees to safely be able to get around it without risking falling over the edge. You'll hear the defendant did none of these things. They were aware that those dangerous conditions existed because you'll see a report from an incident that occurred 10 years before this one, where another employee fell in practically the same spot in practically identical circumstances. But the defendant, rather than make any changes, did nothing. They didn't even do so much as put out a warning or train their employees in fall protection practices. Members of the jury, you'll learn that these failures on behalf of the defendant are what caused Jordan Gilmore's injuries. Because on January 23rd, 2019, when Jordan felt his foot slip at the top of those stairs, there was nothing for him to grab onto. There was nothing for him to stop his fall. So when he went over the edge, there was nothing to keep him from hitting the ground and irreversibly injuring his knee. Members of the jury, today you have the opportunity to hold the defendant accountable for their failures. because employers have responsibilities to their employees to keep those employees safe while they are at work. So in a few minutes, when defense counsel gets up here and tries to tell you that the defendant wasn't responsible for the area where Jordan fell, ask them who directed their employees, including Jordan, to use those staircases practically every single day. You'll see that it was the defendant. And if they try to tell you that the OSHA regulations don't apply to the space that we're talking about, ask them, who is responsible for keeping employees safe while they are at work doing their jobs? The answer you'll see, members of the jury, is their employer. It's the defendant. The defendant had a responsibility to keep Jordan Gilmore safe. Their failure to do so puts them at fault for his injuries. As such, at the end of this trial, I am confident that once you have heard all the testimony and seen all the evidence, you will be able to return the only verdict that that evidence supports and that justice allows. A verdict putting fault for Jordan's injuries where it rightfully belongs and finding Chimes department stores liable. Thank you.
4854 left for plaintiff. All right. And then defense, same thing. When you start talking, I'll start timing.
Thank you, Your Honor. May I proceed? May it please the court. Just because there's a fall, that doesn't mean there's fault. It's a cold, windy evening in January. And the plaintiff, Jordan Gilmore, is standing behind the store where she works. She takes out a pack of Marlboros, taps the bottom, pulls one out and lights it up. She closes her eyes and he enjoys his break. Until he hears his manager calling his name. Break's over. It's time to go back to work. So he goes down the stairs, walks down and throws the butt away in the dumpster, like he's been told. And then he starts back up those stairs. 5 steps. He reaches the top. He takes that final step. And he walks inside. Just like he did the day before. And the day before that. And the day before that. For 10 years. The plaintiff, they told you these stairs, they were dangerous. They told you there wasn't enough light. The stairs were falling apart. You said there was no guardrail, and that was the problem. But the evidence will show these stairs were inspected and approved by a federal safety inspector. The evidence will show that the plaintiff, well, he'd taken these stairs literally thousands of times until January 23rd, 2019. Well, there was no injury, no incident, no accident. The evidence will show that the plaintiff, he didn't fall because there was a problem with these steps. He fell because he tripped. and he tripped. Because sometimes people trip just because there's a fall. Doesn't mean there's a fault. And the plaintiff, they just talked a lot about Chimes department store. I want you to meet the owner, Reese Geller. Ms. Geller, can you turn on your camera? This is Reese Geller. You're going to meet her today. She's going to tell you that she's the owner of Chimes department store. But she hasn't always been. Her grandparents started this business. Single storefront right here in Waco. They had one goal. Whatever you need, whatever you want, you can buy it here. When her grandparents decided it was time for them to retire, her parents took over. And when her parents decided they wanted to retire, she took over. She's run the business for the last 10 years. She'll tell you today that for 3 generations, her family has taken care of their customers and taken care of their employees. Thank you, Ms. Geller. Now, of course, as the defense, we don't have to prove that. We don't have to prove anything. We have no burden of proof. That burden rests with the plaintiff and the plaintiff alone. The plaintiff has to prove their case, every single element, more likely than not. And there's 2 elements today they won't be able to prove. They won't be able to prove that the area outside Chimes was unsafe. And they won't be able to prove that the conditions outside of Chimes caused Mr. Gilmore's injuries. So let's take those one at a time. The first thing that the plaintiff won't be able to prove is that the conditions outside of Chimes were unsafe. See, they didn't tell you this during their opening statement, but less than a year before Mr. Gilmore fell, there was an OSHA inspection of Chimes department store. OSHA, it stands for Occupational Safety and Health Administration, and they are the federal body in charge of workplace safety. You'll hear from the OSHA inspector who came to Chimes, walked through those doors that the plaintiff told you about, walked down those steps, up those steps, the same ones that the plaintiff used. That inspector will tell you, this is a safe place to work. These steps, they're a safe place to walk. And when it comes to safety, the proof really is in the pudding. And the evidence will show that those stairs were safe. You'll learn that the plaintiff started working for Chimes department store back in 2010. As the plaintiff already told you, he took those stairs about 20 times a week. 20 times a week for 10 years. When he went for a smoke, he'd take that smoke out by those stairs. When he went to throw away his cigarette butt, he'd walk down those stairs and throw it in the dumpster. For 10 years. The evidence will show that for a decade, the plaintiff walked up and down those steps and never had a problem. I want to be upfront. As the plaintiff said, there is another employee, someone who fell on those stairs before. But you'll learn that that was back in 2010. And the plaintiff told you in their opening that these were substantially similar conditions, but you'll learn that, well, that man, he slipped on loose gravel. You won't hear evidence about loose gravel today. What you will hear is you'll hear that every employee, every clerk, every cashier, every manager, every delivery driver, every employee who wanted to take a smoke break, took out the garbage, or loaded and unloaded a vehicle, well, they all used those steps. And in the 14 years that Chimes used that building, you'll learn that up until January 23rd, 2019, that was the only single time that someone else has had an injury there. Thousands of steps, thousands of uses. You'll hear that there was almost no problems at all. And that brings me to the second element that the plaintiff won't be able to prove. They won't be able to prove that those stairs, that those conditions actually caused Mr. Gilmore's injuries. As you listen to the trial today, I want you to pay particular attention to what the plaintiff himself says. Because we think there's going to be a gap between what the plaintiff had just told you in their opening statement and what Mr. Gilmore tells you on the stand today. The plaintiff, they're going to talk about how the lights were on. We expect that Mr. Gilmore, he won't say that he went to take that step and he missed because he couldn't see. The plaintiff told you that, well, those stairs were in disrepair, but Mr. Gilmore, he's not going to testify that the step crumbled away underneath him or that he lost his balance because of an uneven staircase. What Mr. Gilmore's going to testify to today is that he walked up those stairs, all of them. And when he got to the top, he put his right foot down. He didn't go for the top step. He didn't just touch it. He put his right foot down. And then something happened. Members of the jury, the plaintiff won't be able to tell you what that something was. The plaintiff certainly won't be able to tell you that that something was caused by Chimes. I want to make sure that this is very clear. We are not blaming Mr. Gilmore. People trip. People fall. But we are asking that you not blame Chimes department store. Because the evidence will show that those stairs have been inspected and approved. They passed a federal inspection. The evidence will show that for years, those stairs were used daily by multiple employees without issue. At the end of this trial, we'll ask you to deliver a verdict in favor of Chimes departments. Just because there's a fall, it doesn't mean there's fault. Thank you.
43 minutes and 8 seconds left. Okay, just give me 1 second. Okay, 48. 54, whenever you start speaking after you've called your first witness, plaintiff's counsel, I'll start timing.
Yes, Your Honor. Your Honor, at this time, the plaintiff calls Jordan Gilmore to the stand.
Mr. Gilmore, you've been previously sworn.
Good afternoon. Can you please introduce yourself to the jury?
I am Jordan Gilmore.
Mr. Gilmore, where are you from?
I am from Waco, Texas.
And how old are you?
I'm 48 years old.
Are you currently employed?
I am not.
And why is that?
I had to leave my job after an injury.
I'm sorry to hear that you were injured, Mr. Gilmore. How were you injured?
It was a fall. I fell down and hurt my knee.
Did that happen at work?
Yes, it did. It happened during work hours on at the department store, which I worked at Chimes.
So we're going to discuss that in some more detail today, but you just said you were working at Chimes. Is that Chimes department store?
That is.
Are they the defendant in this case here today?
Yes, they are.
And what was your job at the defendant's store?
So I was a cashier.
And how long did you work for the defendant?
I worked for over 10 years.
Were you working there on January 23rd, 2019?
Yes, I was. That was the date of the accident.
So I want to talk more about that day. What were you doing before you fell?
I was outside taking a smoke break.
And about what time was that?
It was about 7 in the afternoon.
And you said that you went outside. Where exactly did you go?
So the department store in the back, there's a designated smoking area behind it's like a loading dock area that we all go smoke.
You called it a designated smoking area. Why did you call it that?
Well, that's where we were told that's where we should take our smoke breaks by the manager.
Now, Mr. Gilmore, I'm showing you what's already in evidence as Exhibit 1. I'm sorry, Your Honor, we seem to be having brief technical difficulties.
No worries.
Mr. Gilmore, how did you know that the defendant expected you to take your smoke breaks out by that loading dock?
So a memo went out. This memo right here that's on the screen went out by the manager, Lane Kim, saying that there should be no smoking in the front and to take all the smoke breaks out by the dumpster, which is in the back.
Now I'm highlighting a sentence here. Does this sentence say what you just told us pretty much?
Yes, it says, as you have been told before, if you're going to smoke, you smoke out behind the store where the dumpster is. That is the only place you should take smoke breaks on the premises.
And about how often would you take a smoke break at work?
I take one about once a day.
And other than your smoke breaks, did you ever go into that back area for anything else?
Yeah, roughly 4 to 5 times a day. So we're averaging like 20 times a week to take out trash and take smoke breaks.
Just to clarify, Mr. Gilmore, would you go out there 4 to 5 times a day or 1 to 2 times a day?
I would go out there about 1 to 2 times a day.
And other than smoking, what else were you doing in that area?
Well, we'd take out the trash and then we'd clean up after ourselves, but that's about it.
Taking out the trash, was that something you were required to do as part of your job?
Yes, that is part of my duties.
Now, Mr. Gilmore, I'm showing you what's already in evidence as Exhibit 19. What is this?
That is a picture of the area, that smoking area.
And this dumpster on the right-hand side of the photo, is that the dumpster where you were required to throw away trash?
Yes.
And besides these doors that we see here, was there any other way for you to get to that dumpster?
No, that's the only way. I mean, I guess technically you could walk all the way around the building, but nobody does that. You just walk through those doors.
Besides the stairs we see in this picture, were there any other stairs for you to get down to the ground so you could go over to the dumpster?
No, there aren't.
I want to focus now on those stairs for a minute. Are there any guardrails on the exposed side of that staircase?
No, there isn't.
What about against the side that abuts the wall? Are there any handrails on that wall?
No, there aren't either.
Was there anything on these stairs for you to hold on to so you could steady yourself?
No, there wasn't.
And was there anything on that wall for you to grab onto if you lost your balance?
No.
Thank you, Ms. Goja. You can take that down. Now, Mr. Gilmore, I want to talk about your fall itself. Can you walk us through what you did when you went outside that night?
So I was just doing my usual thing. You just walk out there and you smoke a cigarette, and then I was just walking up. January, it's cold, so I just headed back up the stairs.
Now, when you went outside to smoke, were you alone?
No, I had a coworker, Riley, with me.
Did Riley walk down the steps as well?
No, she was holding the door open.
Now, you said earlier that when you went outside, it was about 7 p.m. What was the light like outside at that point?
So it was essentially pitch black. In January, the sun goes down around 5 or 6. So you can't see much.
And are there any lights outside of that back door?
No, there aren't any lights there. The only light is the one that comes through the door when it's propped open.
Do you know if there are any lights that you didn't have the ability to turn on?
There is a light out there, I guess, in the sense that a potential light, but I've never seen it turned on.
And do you know where the switch for that light is located?
It's located in the adjacent store. I believe it's a Home Depot. So we can't really access it.
Now, did you ever ask the defendant if they could do anything about the lack of light outside?
Yes, we asked them, but the reply was always that there is more important things to do. Like we'll get to it eventually.
Now, going back to January 23rd, after you were done smoking your cigarette, what did you do next?
So I headed up the stairs. Only take a break for like 4 or 5 minutes.
Now, Mr. Gilmore, I'm showing you what's already in evidence as Exhibit 3. What are we seeing here?
So this is the stairs from a top-down view.
And is this how the door was open on January 23rd, 2019?
Yes, that's how the door was open.
So using this image, can you walk us through what happened when you came up the stairs?
Yeah, so imagine this image, but it's dark, so you can't see anything other than the light coming through the door. And as I head up, I'm just walking normally up the stairs. I take a step, that last step right there, and I slip. I don't know, I'm not sure if it was loose, concrete, you see all the crumbly parts there, or what it was. And then naturally, I just try to catch myself, jump back, land on both my feet, but it's a little bit of uneven. So I guess my weight went to my right side and I fell back onto my rear end.
Mr. Gilmore, I just want to clarify a couple details here. To be clear, did you start to fall when you got to the top stair in this picture?
Yes.
I'm indicating an area with a red circle here on Exhibit 3. Does this accurately reflect where you put your foot before you fell?
Yes.
Is that right next to the hole that we see on the corner of that step in the cement?
Yes.
Now, Mr. Gilmore, you said that when you fell, you tried to steady yourself. Is that right?
Yes, that's true.
And was there anything for you to steady yourself on?
No.
Your Honor, I'm sorry, Your Honor, the demonstrative was pulled a little prematurely, but motion to preserve this as demonstrative Exhibit 3A.
Any objection?
No objection, Your Honor.
Yeah, that's fine.
Now, Mr. Gilmore, were you injured as a result of this fall?
Yes. So I had to have a total knee replacement because the next day I went to the hospital.
Now I want to move on to what happened after you fell. What happened next?
So Riley was there and she came down and she helped me back up. And then I filed a complaint with the manager. Well, not a complaint, just an injury report. And then I went back to work, finished that shift off.
Now that manager that you spoke to, who was that?
That was Lane Kim, the same person who sent the memo.
And when you told her what happened, did she say anything?
Yeah, she apologized, and she said that she was sorry and that they should have gotten it fixed earlier, but it just wasn't important. Basically the same thing that when we complained about the light.
Now, when Lane Kim said this to you, did she say, we should have gotten this fixed?
Well, I'm assuming in the we, she meant Chimes, like the department store, like collectively.
Okay, Mr. Gilmore. Now I want to go back to who was responsible for that area where you fell. And I'm going to pull up Exhibit 1 one more time. This is the memo that we talked about earlier.
Yes.
Now, if we could just enlarge the second sentence of this last paragraph. Can you please read this to the jury?
Yes, it says, so if you take a smoke break out by the dumpster, please take some time to clean up the area, pick up any trash you see, and make sure that you dispose of your cigarette butt in a manner that doesn't add to the problem.
In your time working for the defendant, did you ever see anyone from the landlord's office cleaning up that area?
No.
Did you ever see anyone who wasn't an employee of the defendant cleaning up that area?
No.
Now let's move to the last sentence in that paragraph. Can you read this for the jury?
It says, we want to make sure we keep our area clean and presentable.
And what is the defendant telling you is our area in this sentence?
So it's the entire thing, because when you go down and you smoke at the bottom of the stairs, so I guess the whole thing.
That area they're defining as our area. Does that include where you fell?
Yes, it does.
Thank you, Mr. Gilmore. Your Honor, no further questions at this time.
36 minutes and 33 seconds left. Okay, 43:08. Okay, Cross whenever you're ready, and I'll start timing when you start talking.
Thank you. Good morning.
Good morning.
Afternoon, rather. Mr. Gilmore, can you see and hear me okay?
Yes. Did you say something?
I said good afternoon.
Oh, okay. Good afternoon.
How are you doing, sir?
Well, my knee is blasted, so it really hurts, but I'm surviving.
Let's start off by talking about the stairs outside the store, the ones that your counsel was showing me. January 2019, that wasn't the first time you'd taken those stairs, was it?
No.
You started working at Chimes department store in 2010, was it?
Yes.
Chimes policy was that smoke breaks should be in the back of the store.
Yes.
You followed that policy.
Yes.
You would walk out that back door.
Yes.
Onto the platform.
Yes.
Down those stairs.
Yes.
That's when you'd smoke cigarettes.
Yes.
So let's get a sense of how many times you went up and down those stairs before the day of the accident. Ms. Campbell, can you bring up a calculator? Mr. Gilmore, you smoke about a pack a day, right?
Yeah.
You use those stairs to take out the trash.
Yes.
Between the smoke breaks and the trash trips, you estimate that you use those stairs about 20 times a week.
Yes.
But when you went down the stairs, you'd come back up the stairs, right?
Right.
So those were round trips.
Yes.
You were a full-time employee, right?
Objection. Your Honor, the use of the calculator like this is misleading.
Okay, let's hear it. Let's hear the objection.
Your Honor, the plaintiff has testified here consistent with his deposition that he used the stairs about 20 times a week. That means he went up and down them. That does not mean that the defense can now double that number here today to try to make it look like the use was more than it clearly was. Using the stairs is going up and down them.
Response.
Your Honor, this witness used the stairs twice when he went down the stairs and then up the stairs. That's not misleading.
Any response to that, Ms. McGuigan? I did hear him testify that, he asked him right on direct examination if he was going up and down the stairs within those uses. Did he not? Did I mishear that?
Your Honor, maybe I misheard it, but it sounded like he asked him, did he go up and down the stairs in those uses? And Mr. Gilmore said yes, which would mean that one use is up and down the stairs.
Okay, I'll tell you what. Why don't I'm going to overrule the objection for now. If we want to get stuck, I advise you that it's kind of silly to maybe get stuck on this point. But if we do want to get stuck on this point, we want to explore if it's 20 or 40 times, potato, potato, you're free to do so, but I need you to get him to, answer that question and explain that I agree, we're not going to mislead the jury if it's, so Ms. McGuigan, you can object at that time if you feel he hasn't done it, okay?
Yes, Your Honor.
But I'm overruling that objection for now. So give me 1 second to get your time back going. Whenever you start talking, I'll start it.
Mr. Gilmore, you're a full-time employee, right?
Yes.
So you worked about 50 weeks a year.
Yes.
You worked for Chimes Department Store for 10 years.
Yes.
It's fair to say you took those stairs thousands of times, right?
Yes.
On direct examination, you showed us what those stairs look like.
Yeah.
Opposing counsel, they asked you about the lighting, right?
Yes, they did.
You told us there wasn't a guardrail.
Yeah.
But every one of those thousands of times that you used those stairs, they were in roughly the same condition, right?
Yes.
And every one of those thousands of times before January 23rd, 2019, you never hurt your knee on those stairs.
No.
You never fell off those stairs.
No.
You never hurt yourself on those stairs.
No.
In fact, you would say that for the thousands of times using those stairs before January 23rd, 2019, you never had any trouble getting down the stairs?
No.
Never had any trouble getting up the stairs?
No.
So let's talk about the day you were hurt. Around 7:00 p.m., that's when you went outside to smoke.
Yes.
It was dark out.
Yes.
This wasn't the first time you took a smoke break at night, was it?
No, it was not.
The outside light, it was off.
Yes.
You and your friend, you kept the door open, right?
Yes.
You used the light from inside the store.
Yes.
It wasn't the first time you'd done that either, was it?
No.
You walked down the stairs.
Yes.
You were able to see well enough that you could make it down the stairs, right?
Yes.
You didn't fall.
No.
You didn't slip on the way down either, did you?
No.
The night of the accident, you had no trouble getting down the stairs.
No.
Okay, so let's focus on what caused this accident. Once you got to the bottom of the stairs, you smoked your cigarette.
Yes.
And when you were done, you threw away the cigarette butt.
Yes.
You started walking back up the stairs.
Yes.
There are 5 steps, right?
There are.
At the top of those 5 steps, and that's where you get the landing platform.
Yes.
You remember, you put your foot onto that platform, right?
Yes.
Your right foot.
Yes, I believe. Yes.
I want to be clear. You didn't just extend your right foot toward the platform.
What do you mean?
Well, you didn't just move your right foot towards the platform and then put it down and miss, did you?
No, I stepped on it.
That's right. So your right foot didn't just graze the platform or just touch it. You stepped right on the platform.
Yes, I guess so.
And then, in your own words, something happened, right?
Yes, I slipped.
You were deposed in this case, right?
Yes.
You told us everything that you knew about that accident.
Yes.
The only description that you gave of how your foot left the platform is that something happened.
Objection. Your Honor, this is an improper impeachment. May I be heard?
You may.
Your Honor, in his deposition, Mr. Gilmore said something happened and I felt my foot slip. So him saying that he slipped is consistent with his prior testimony, and this is an improper impeachment.
Response?
I'm sorry, Your Honor, I should have been clearer. I'm not trying to impeach this witness here. I'm just asking what he said in his deposition.
Yeah, I mean, I agree. I don't know that it does sound like you're laying the foundation for an impeachment. So, I mean, I don't think the objection was totally out of place, but so long as you're not doing that, it sounds like we don't have a disagreement. So, going to overrule the objection again, Ms. McGuigan. If he, starts going down that path, objecting, we'll take it up at that time. Okay.
Yes, Your Honor.
Okay. Whenever you start talking, I'll start timing again. 36:35.
So before your foot slipped, the only description of what happened is something happened, right?
Yes.
On direct examination, you mentioned crumbling concrete. So I want to be clear, you don't recall the stairs crumbling loose underneath your foot.
Oh, no. Not like a
You don't
mud.
recall the concrete giving way.
No.
The pipe you pointed out on direct examination, you don't remember feeling that pipe underneath your foot.
No.
You don't recall any water on the stairs.
No.
You don't recall losing your balance because it was uneven on the steps.
No.
In 10 years, working for Chimes, well, this was the first time you'd ever had any problems with those stairs.
Yes.
This was the only time you ever had any problems with those stairs.
Yes.
Thank you. No further questions.
Okay. 35:21. Any redirect? Ms. McGuigan?
Yes, Your Honor.
Okay, let me get your time set again. Okay. 36:33, whenever you start talking.
Mr. Gilmore, defense counsel just asked you if this was the only time that you had problems with these stairs. Why didn't you have any problems with these stairs after you were injured?
Oh, after I was injured, well, I didn't go back to work because they filled my spot because I couldn't come back immediately because I was hurt.
No further questions, Your Honor.
36:09. Okay. Calling any more witnesses, Ms. McGuigan?
Your Honor, at this time, we will be calling Kelly Danes by deposition.
Okay.
As we discussed in pretrial, she is unavailable.
Excellent.
Your Honor, we would like to constructively move in Kelly Danes' deposition in its entirety. And then my co-counsel will come on screen and we will read certain portions out so that the jury can hear them.
Any objection?
Yes, Your Honor. We have no objection to portions of this testimony being read aloud, but we object to admitting this deposition in its entirety under Federal Rule of Civil Procedure, Rule 32C.
Okay. Response?
Your Honor, first of all, we discussed this with opposing counsel prior to the trial here today, and we were not made aware of any objections that they have to portions of this testimony being constructively provided to the jury. Had we been
Well, hold on. He didn't have any problems with any portions of it constructively being read in, but did you not also move to have the entire thing admitted? Isn't that what I heard you say? I thought I heard you say that, and that's what he's objecting to.
Your Honor, we are moving to, I apologize if I was unclear. We are moving to constructively read it in its entirety and now highlight certain portions so the jury can hear them via question and answer format with my co-counsel.
Okay.
In that case, Your Honor, I move my objection under Rule 403 to needlessly cumulative. If the entire thing is being constructively read in its entirety, then certain sections don't need to be also read in non-constructively.
I would agree with that, but I'll let you respond, Ms. McGuigan. Why do we need to get the entire deposition in constructively? I'm not understanding.
Your Honor, if you would prefer, we are happy to just limit the read-ins to the portions that we will read out loud in question and answer format here today. We were just, for the sake of convenience, providing the entire deposition so that the jury may be able to reference it later while they are deliberating if there are certain codes or certain things that this witness discusses. However, we can limit it to the portions here that we are going to read out.
I think that's for the best, so I'll sustain the objection. Yeah, we're just going to go with what she's reading in. So you've got 36:09 on the clock. When you start, constructively asking her the questions, I'll start timing.
Yes, Your Honor. Directing court and counsel to page 2 of Kelly Danes's deposition, beginning on line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Moving now to line 12. Tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Moving now to line 24. I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
And what do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well, and I passed.
Moving now to page 5, line 14. All right, Kelly, I want to move now to talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Moving now to page 6, line 14. Are exhibits 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when he fell, but other than that, this is the same area and how it looked.
What do those pictures show?
Well, as you can see, there are no railings on the steps up to the top of that landing area, and there is no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see this is a pretty dangerous situation.
Your Honor, at this time, while we have not offered exhibits 16 through 21, all 5 of those into evidence, we have pre-admitted exhibit 19, and we'd like to show that to the jury so they can see what this part of the deposition is discussing.
I assume no objection to that, Mr. Ayers, right?
No objection.
Okay, go ahead.
Just a moment, Your Honor. Technical difficulties.
Yeah, no worries.
Thank you, Ms. Goja. Moving now to page 7, line 5. Are exhibits 22 through 30 fair and accurate depictions of how those areas appeared at the time of your inspection?
Yes.
And what do those pictures show?
Well, there are multiple stores in that little strip center, and they all have some kind of landing area and steps behind them, just like Chimes. However, as you can see from these photographs, nobody else has removed the railings from those areas. So what you see in these photographs is what the landing area behind Chimes would have looked like with railings and what it should have looked like in order to be safe.
Once again, Your Honor, we are not offering exhibits 22 through 30. We have only pre-admitted exhibit 22. So we ask to be able to show the jury that now.
Of course.
Thank you, Ms. Goja. Moving now to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Moving now to page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
Those are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Moving now to page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chime store. So there was no way for employees to turn on that light when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Moving now to line 24. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Moving now to page 14, line 22. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully opened, the door shall not project more than 7 inches into the required width. When the door is open, like it was at the time of this incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken those simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
Your Honor, this concludes the portions of Kelly Daines' deposition that we are offering into evidence.
Okay, 2834 left. Counsel for defense, are you going to read any portions of that deposition as well? Are you doing that at this time?
Yes, Your Honor, as a form of cross-examination.
Yeah, absolutely.
Ms. Campbell, my second chair, will be playing the part of the expert here.
All right, let me reset your time real quick. 35-1 left, and whenever you start, I'll start timing.
Thank you. This is on page 4, line 11. Question: have you ever worked in code enforcement at any level of the government?
No, I've always been in private practice.
No further questions, Your Honor.
3507. Okay, plaintiff, anything further?
Yes, Your Honor. Before we rest, we would just constructively read in the portions of the International Building Code and the OSHA regulations that Kelly Danes referenced in the portions of her deposition that we read in.
Any objection to that, defense?
No objection, Your Honor.
Okay. It is so read.
Your Honor, with that, the plaintiff rests.
Okay. So defense, if you're ready to start, you can call your first witness.
Your Honor, before that, we have a motion that we'd like to be heard outside the jury's presence.
Sure. Go ahead.
We move for judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even viewing the evidence in the light most favorable to the plaintiff, no reasonable juror could find the plaintiff has met their burden. We focused on the element of causation. The plaintiff presented evidence that the injury occurred at the work site, but not because of the work site. In the plaintiff's own words, I stepped on the landing, something happened, and I slipped. Something happened is insufficient to establish causation and thus liability. The defense requests judgment as a matter of law.
Response.
Yes, Your Honor. Viewing the evidence in the light most favorable to the non-moving party, here the plaintiff, we have made a prima facie showing upon which a reasonable juror could find that it was the unsafe condition of those stairs that caused Jordan Gilmore's injury. We heard from Mr. Gilmore that as he came up those stairs, when he stepped on the landing, he felt his foot slip and subsequently fell. We then presented photos of that very landing that showed cracked concrete, a open hole on that landing where a railing used to be, and the complete lack of any safety measures that would have protected Mr. Gilmore. Taking all of this together, Your Honor, we've clearly made a prima facie showing that shows that it was the unsafe conditions at the worksite that caused Mr. Gilmore's injuries.
Okay, I'm going to deny that motion. Defense, you can call your first witness.
Your Honor, the defense opens its case in chief with the deposition of OSHA Inspector Hayden Perry.
Okay.
The witness is stipulated unavailable, and the plaintiff had an opportunity to cross-examine just as Kelly Danes. We provided with the opposing counsel with a highlighted copy of the transcript showing which sections we're going to be reading it.
All right.
Again, Ms. Campbell will read the answers while I read the questions.
Sounds good.
One moment, Your Honor.
Yeah, whenever you're ready.
Beginning on page 2, line 11. Question, what do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
And what do you do, moving to line 22. Question, and what do you do at OSHA as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Moving to page 3, line 16. Question, how long have you worked for OSHA?
Since I got out of school, so at this point, that's about 13 years.
Moving to page 5, line 6. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Moving to line 20. Question, so were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we had been there. That's it.
Moving to page 6, line 8. Question, did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
No further questions, Your Honor.
Okay. 3322. Anything for this missing witness? Plaintiff, if you want to do your Cross.
Yes, Your Honor.
Okay, let me set your timer up real quick. So you've got 28:34 left. And whenever you're ready.
Beginning on the same page, page 6, line 22. When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving now to page 9, line 23. Ms. Hayden, I'm showing you what has been marked as Exhibit 38. Do you recognize this?
Yes, this is an email that I received from one of my superiors in May 2019.
Moving to line 5, do you disagree with the assessment of your boss in this email?
No, I don't.
Your Honor, at this time we offer Exhibit 38 into evidence.
Any objection?
I don't believe so, Your Honor. I'm just checking on the exhibit itself.
Okay, let me know when you're.
No objection.
Okay. It is so admitted, and you may publish it.
Yes, Your Honor. Publishing Exhibit 38 and blowing up the paragraph. And 38 states, I noticed that you continue to issue very few citations when out inspecting workplaces. In fact, I compared your numbers with the others in the Central Texas region, and you have issued the fewest citations of any inspector we have on staff. In fact, over the past 5 years, you have issued less than half as many citations as the next closest inspector. This is a problem. Returning now to Perry Hayden's deposition. Page 11, line 18. Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
And did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
And did you have them turn it on for you while you were there?
No, didn't seem necessary.
This concludes our portions for this witness, Your Honor.
2608. Any redirect of that?
No, Your Honor.
Okay. Let me get your time up and you can go ahead and call your next witness.
Your Honor, we call Reese Geller.
All right, Ms. Geller, you've been previously sworn, so you're good to go. Whenever you start talking, I'll start timing.
Good afternoon.
Hi,
Can you see and hear me okay?
I can.
Please introduce yourself to the jury.
My name is Reese Geller.
Where do you live, Ms. Geller?
I am in Waco, Texas.
Where did you go to school?
I went to Baylor University right here in Waco.
And what do you do for a living?
I am the owner of Chimes Department Store.
Let's talk about what Chimes is. How long have you been the owner?
I've been the owner for 10 years now.
And who owned it before you?
So it's actually a family business, so my parents owned it before me.
Who owned it before your parents?
And then my grandparents before my parents. So hopefully my kids will get it as well.
What kind of store is Chimes?
It's kind of like a mini J.C. Penney's or Home Goods. You can get tools, clothes, anything you need really.
And I know you said you live in Waco, but where is Chimes located?
It is located on Bosque. It's a really busy street in Waco.
How long has Chimes been in Waco?
Since, well, as far as I know, since 1988 is when I started working there.
Let's start off by talking about the stairs behind the department store. In your electronic notebook, could you take a look at the last page of Exhibit 11? I think it's marked 11A. And let me know when you see it.
Okay, I have it pulled up.
What is the last page of Exhibit 11?
The last page of Exhibit 11 is a site map.
And can you find Exhibit 12 in your electronic notebook as well?
Okay.
What's Exhibit 12?
That is a picture of the site map as well.
What's the difference between Exhibit 11 and Exhibit 12, just looking at it?
It shows the area behind my store with the red X.
Are Exhibits 11A and 12 accurate copies of the site plans for Chimes?
They are.
We offer Exhibits 11A and Exhibit 12.
Any objection?
No objection, Your Honor.
Okay, it's so admitted and you can publish them.
So we've got Exhibit 11A up now. And I believe Ms. Campbell's just highlighted an area in blue. What is that area?
That area is where my store is located inside the building.
And now we're going to put up Exhibit 12. Once you see it, can you let me know exactly what that red X refers to?
That red X refers to the area behind my store.
What do you use that area behind your store for?
We used it for a loading dock to get all of our products into the store. Occasionally, people would take smoke breaks out there, and our trash can is also located outside in the back.
Well, let's take a look at what that area looks like. Ms. Campbell, could you republish what's already in evidence as Exhibit 19? Ms. Geller, what are we looking at here?
That is a picture of the back of my store.
We've heard that there used to be a railing on these stairs. Is that true?
It is.
What happened to the railing?
Back in 2005, when my parents still owned the store, they requested that Kermit Realty remove the railings so we could have the loading dock in order to get all of our products inside.
Can you be specific about why exactly that railing needed to be removed in order to get those things inside?
Yeah, we had so many products that we were getting deliveries routinely, and we needed to be able to deliver those products into the store more conveniently.
And how would removing that railing help get deliveries and products into the store more easily?
We would just back the truck up to the loading dock and unload it from there.
How often does Chimes use this platform for deliveries?
We use the loading dock every day.
Now, we've heard today, and indeed you said, that this isn't just used as a loading dock. Is that true?
Yes.
What other things is this back area used for, as well as being a loading dock?
The employees need to take the trash out, so they need to use the stairs to get to the dumpster. And then we have a lot of employees that take smoke breaks, and I request that they smoke in the back.
Why did you request that they take their smoke breaks at the back?
I would just like to keep a professional environment, and I don't really want customers seeing employees smoking at work, and some people are offended by the smell, so I think it's best if they just are out of customers' views.
Ms. Geller, I want to be upfront with the jury. Did you know that your employees would be using those stairs, the ones in Exhibit 19?
Yes, I did.
So let's talk about safety. Were you here a few minutes ago when we read the deposition testimony of the federal safety inspector?
Yes.
Has Chimes ever gotten a safety citation for those stairs?
Never.
Has Chimes ever gotten a safety citation for that loading dock?
Not that I'm aware of, no.
Have you ever been told that that dock violates any safety codes?
I have not.
What year did Chimes move into the space it's in now?
2005.
So how many years passed from when Chimes moved into the store and January 23rd, 2019, when the plaintiff was injured?
14 years.
During those 14 years, if an employee was injured on the job, how would you learn about it?
So the employee would fill out a report with the manager, and then I would be notified.
During those 14 years, how many employees are you aware of who claimed to be injured on those stairs?
I was aware of one.
To your knowledge, how often were employees using that stairs or using those stairs during the period when one injury was reported versus when no injuries were reported?
Same amount of employees then as now, and they use it daily all the time.
Let me make this clear. For the last 14 years, have you seen a massive increase or decrease in the use of those stairs?
No, it's the same.
So to your knowledge, how often were employees using those stairs? And let me rephrase. Let's talk about that injury, the one that you had heard about prior to January 23rd, 2019. To your knowledge, when was that injury reported?
Like, when was it reported to the manager or to myself?
To the manager.
Oh, immediately following the accident.
Do you know what year that was?
9 years. I believe it was 2010.
So between 2005, when your company originally moved into that building, and 2010, how many injuries occurred on those stairs that you know about?
0.
And how many years passed between that injury in 2010 and January 23rd, 2019?
9 years had gone by.
During that time, Ms. Geller, have you seen what that back area looks like?
Yes.
And how did the condition of those stairs when the plaintiff was injured compare to the condition of those stairs when that other employee was injured 9 years before?
I haven't noticed any changes.
Thank you. No further questions.
Okay, 2252. Okay, and then we've got 2608. And whenever you start talking, Ms. McGuigan, I'll start timing.
Yes, Your Honor. Good afternoon, Ms. Gilmore.
Hi.
You're the owner of Chimes Department Stores, correct?
That's right.
So I want to start by talking about the landing area on the back exit of the store. There are no guardrails on that area, correct?
That's right.
There are no guardrails on that staircase.
No.
The store had them removed.
Yes, we requested for the landlord to remove them, and he followed our request, yes.
The landlord didn't say this is a common space.
So it actually is a common space because if it was our space, we would just take down the poles ourselves. But because it's a common space, we have to request that he make any changes to the infrastructure.
Ms. Geller, I'm only asking you what the landlord said when you made that request, and they did not say this was a common space.
He said he would remove the guardrails.
He agreed to do what you requested, isn't that right?
Right.
Now, Ms. Geller, I'm showing you what's already in evidence as Exhibit 19. Just one moment, Your Honor. This is a picture of that back entrance, right?
It is.
The staircase here, it doesn't have any guardrails either.
Like I said, yes, it does not.
Sorry, Ms. Geller. You'd agree that guardrails are meant to protect people from falling off of stairs.
Yes.
There's also no handrail on the wall that staircase is against.
No.
Handrails are for people to hold on to while they're on stairs.
Mm-hmm. Yeah.
People can't hold on to handrails if there are no handrails in the first place, right?
Yeah, sounds right.
Now, Ms. Geller, I'm adding a red circle to this exhibit. Does this circle depict where the light was outside of that back exit?
It does.
Now, at the time, your employees couldn't turn that light on, right?
No, we did not have a switch to it.
The switch was in a different building.
Yeah.
You could have asked the landlord to put that light on a timer.
Well, that's his area. That's not, the back is not our property.
Directing you back to my question, Ms. Geller, you could have requested that the landlord put that light on a timer, correct?
Objection, Your Honor. Calls for speculation. This witness doesn't know what that landlord could have done.
May I respond?
You may.
I'm not asking her to speculate as to what the landlord could have done. I'm asking her if she could have made the request. We've already discussed one request that they made as to this outside area. I'm merely asking if it was possible that she could have made another one.
I agree. I'm going to overrule that objection. Go ahead and continue.
Yes, I could have requested it, but it does not mean that he would have done so.
Now, if that light had been on a timer, it could have come on automatically at night, correct?
On a timer automatically, I have no idea. I think you mean like motion sensor.
Okay, Ms. Geller, let's move on. You didn't ask that this light be put on a timer, right?
A timer, no.
You also could have asked the landlord to install a switch for that light in your building.
Yeah.
If you'd done that, your employees could have turned this light on themselves.
The light is not part of my property. It is the landlord's responsibility.
Ms. Geller, I'm not asking you what your property is. I'm asking you if it was possible for you to make a request that the landlord install a switch for that light in your store. And that was possible, right?
I could request probably anything I want. It doesn't mean it would happen.
But you could have made the request.
To alter somebody else's property, I suppose so, yes.
And you did not make that request.
It's not my property, so I did not.
Now, I want to talk about how your company uses that landing. Your employees use it a lot, right?
Every day.
To your knowledge, only your employees use that area.
That's correct.
To your knowledge, no other stores use that landing for anything.
No.
No other stores clean that area.
No.
Now, Ms. Geller, I want to go to a section of your lease. I'm showing you page 13 of that lease. This is from Exhibit 11, Your Honor, Section 7.4. This section governs the disposal of trash, right?
It does.
On the third line, it says the tenant shall store all trash and garbage within the demised premises.
Objection, Your Honor. Relevance?
Well, let's hear the argument, I guess. I mean, she just started the line of questioning. I don't know how we can already know it's irrelevant. You want to just briefly tell me, plaintiff, how this is relevant?
Yes, Your Honor, as an offer of proof on direct examination, Mr. Ayers showed Ms. Geller an exhibit of the site plan that was attached to this lease, and then drew a blue box to show that where the loading dock was located and where the garbage area was is outside of the premises that the defendant leased. Here we are showing that pursuant to the terms of the lease, they were required to get rid of their trash inside the demised premises. And as such, the fact that they placed a dumpster outside of that blue line means that they were exercising actual control over an area that extended beyond that limitation, and therefore made this an area over which the defendant exercised control and was therefore responsible to keep safe.
May I be heard, Your Honor?
You may, briefly.
We're not contesting control. We had the opportunity to bring an affirmative defense stating that this was under the auspices of the landlord here, but we chose not to do so. We're not contesting whether this witness or her company, Chimes, controlled this back area.
Okay, but the witness has repeatedly talked about how it's not her property, right? So that, I mean, I think it's highly relevant to the testimony that she's given, right? She's repeatedly emphasized that, it wasn't her light, so on and so forth. I'm going to allow the questioning. I think it's relevant to the testimony that's been given at this point. And I think the jury should be able to hear that. So 21 remaining whenever you start talking again. So overruled, excuse me.
Now, Ms. Geller, on the third line of this section, it says that the tenant shall store all trash and garbage within the demised premises, correct?
It does.
And the tenant, that's your department store.
Yes,
Now, you store your garbage in a dumpster by the stairs behind the building, isn't that right?
it is.
You ordered that dumpster.
I did.
The landlord didn't order it.
Mm-mm.
That's a no?
That's a no.
You decided where to put that dumpster.
I guess, yeah.
The landlord didn't decide.
No.
And you put that dumpster by the landing at the back entrance
Yes,
for employees to throw away garbage.
yes,
You did that without telling the landlord.
yes,
Now, you also direct your employees to take smoke breaks out by that dumpster.
yes,
You direct them to do that and not to smoke out by the front of the store, isn't that right?
yeah, definitely.
Now, I want to talk about what you knew about this area. You knew that Mr. Gilmore was not the first person to fall and hurt themselves on these stairs, correct?
Yes,
Ms. Geller, I'm showing you it's already in evidence as Exhibit 14. This is an accident report from a prior accident that happened on those stairs. Ms. Geller?
yes,
Okay, moving now to enlarge the bottom paragraph. This accident took place on January 8th, 2010.
I'm sorry, are you asking me or are you reading it?
I am asking you to confirm that that is indeed what this report says.
Yes, it is on 1/8/210.
At 7:15 p.m., correct?
Yep,
Now, looking at this section, in this report, the employee alleges that it was dark out, right?
yes,
And that the light was off outside.
yes,
So he went to ask his manager if he could turn the light on.
yes,
He was told he couldn't turn the light on.
that is correct. We don't have access.
And then the employee slipped and fell on the stairs.
Yes,
Now, I want to move to page 2 of this exhibit. Here it says, was the accident caused by faulty or malfunctioning equipment, right?
yes,
And in the answer, the employee wrote, well, the lights weren't on and there were no guardrails, if that's what you mean, right?
yes,
Now we're going to go to the bottom of page 3. Here it says, are there any steps that should be taken by Chimes to help prevent such injuries in the future, correct?
yes,
And your manager said, make sure there is adequate lighting on the loading dock.
yes.
You never did that, did you?
like I said, that is the landlord's responsibility.
Ms. Geller, I'm not asking you whose responsibility you think it is. I'm asking you whether you followed your own manager's suggestions here and made sure there was adequate lighting on that loading dock, and you didn't, correct?
Well, I am the owner, so I will not take, I will do what I am going to do and not what my manager tells me to do.
Objection, Your Honor, is non-responsive. It's a clear question and she's refusing to answer.
Yeah, I'm going to instruct the witness to answer the question that's being asked and not to extemporize. Just go ahead and answer the question that's being asked.
So Ms. Geller, the store never did make sure there was adequate lighting on that loading dock, correct?
Correct.
And this was 10 years before Jordan Gilmore fell?
9.
9 years before Jordan Gilmore fell?
9.
That's a yes?
Yes.
Sorry, Ms. Geller, is there something that's funny here? Let's move on, Ms. Geller. Ms. Goja, you can take that down. Finally, I want to talk about the warnings you provided to your employees about this area. You didn't post any warnings about the drop from that ledge down to the ground?
No.
You didn't post any warnings about the lack of a guardrail on the stairs outside?
No.
You didn't post any warnings about the lack of a handrail on the wall outside?
No.
You didn't post any warnings about there being no light outside?
No, I did not, because it is not my property.
Your Honor, move to strike everything after no, I did not.
Any response to that?
Your Honor, she was answering the question.
You know, the jury's already heard it. I mean, there's no reason that we need to strike it. Let's just move on.
Yes, Your Honor.
The witness is admonished. Let's just answer the questions. No more extemporizing, please.
Ms. Geller, you didn't limit access to that area to authorized employees only, correct?
I'm sorry, could you repeat the question?
You didn't limit access to that landing and stairs to authorized employees only, right?
I did not limit the access, no. Anybody is available to go right there.
And you didn't provide any training to your employees about fall protection before they went out onto that landing, correct?
No.
No further questions, Your Honor.
1544 remaining. Any redirect of this witness?
No redirect, Your Honor. May this witness be excused?
She may. Okay. So let me just ask quick, does anybody need a comfort break, including the jurors? Does anybody need a minute or anything like that? Or are we good to go into closings?
Your Honor, if we may have a few brief moments before closings.
Okay, yeah, let's try to keep it under 5. And what I'm going to ask is, jury members, if you leave or anybody leaves, including second chairs, turn your camera on, please, so we can just verify that you're out of the room. Okay. All right, we got Mr. Ayers. My jurors or my fellow judges, my instructions were to turn your cameras on if you've left. Can I just get a confirmation before we get started that all my judges, Mr. Kent's in the room? Let's see. There's Miss Metz, excellent, and Miss Cunningham, awesome. Yeah, the judges are all deducted 10 points for misbehaving. I'm joking. Okay, y'all can turn your cameras off. Second chair, is everybody else ready to go? Are we good? Okay, good deal. So let me get the time on. Okay, 15:44. And then, like we said, you know, I don't know that we're going to get there, but if we do, 5 minutes, I'll give you the 5, 4, 3, 2, 1. I'll even give you 30 seconds, 15, and then we'll count down from 10 when you got 10 seconds left.
Yes, Your Honor. And before I begin, I would just reserve any time that I have left over when I am finished my closing argument for rebuttal.
Of course, sounds perfect. So whenever you start talking, I'll start timing.
Yes, Your Honor. The defendant failed their employees, and their failures make Jordan Gilmore's injuries their fault. The defendant had a responsibility to their employees to keep their back stairs reasonably safe, and they failed in every respect. They failed in their general safety obligations, and they failed in their specific requirements to provide adequate lighting, to provide safety railings on those stairs, to make sure the door on the landing did not open too far, and to provide warning and safety training to their employees. Failure after failure after failure created the conditions that led to Jordan Gilmore's horrible injuries. So today, the defendant bears the fault for those injuries. Now we're going to talk about every single way in which the defendant failed their employees, but before we do that, we have to talk about their failure to take responsibility today. Because you just heard from Ms. Geller on the stand, and she claimed over and over again that this space wasn't their responsibility. So let's talk about that. The defendant exercised control over this area through their words and through their actions. Now, the defense showed you a diagram that outlined the leased space and then put a red X separate from that space. But members of the jury, the judge is going to instruct you that control can be proven through either a contract or through actual conduct, the way somebody speaks and behaves in a space. And the evidence you've seen here today makes it clear that the defendant acted as if they controlled this space. They specifically directed their employees to use those stairs on a daily basis. Control. They specifically directed their employees to use that back area when taking smoking breaks. Control. And when they moved into this space, they asked the landlord to change that space so they could use it how they wanted. Control. Members of the jury, whatever the lease says or doesn't say, it doesn't matter. The defendant acted as if they were in control of this space. So Ms. Geller can come here and claim otherwise as much as she wants, but that is disingenuous at best. This was a space that the defendant controlled and used on a regular basis. And because of that, the defendant had a general obligation to keep that area safe. They were the employer. They were the ones directing their employees to go up and down those stairs to perform parts of their jobs. You heard from Kelly Danes today, and she told you that that meant they had a general obligation to keep the area free of things that were unreasonably dangerous and obviously hazardous. And members of the jury, your common sense alone tells you that these steps were not safe. You saw the pictures that we showed you today. You saw the broken concrete, the lack of railings, the open hole on that top floor. We see it right here in Exhibit 3. That is clearly something that common sense alone tells you is not safe on the best of days, much less when you're walking up those stairs in the dark with nothing to catch you should you fall. The defendant was responsible for keeping that area reasonably safe, and they failed. And then Kelly Danes walked you through all the specific ways in which the defendant failed, beginning with the lighting. Pursuant to OSHA regulations, the defendant had an obligation to provide adequate lighting on that staircase so their employees could see as they went up and down the stairs. regardless of how dark it was. You heard they didn't provide any lighting at all. The only light that made it out there was light that might spill through that half open door because the defendant did nothing to make sure it was otherwise. And Ms. Geller can get on the stand all she wants and say that it wasn't her obligation and that, well, I can request it, but I'm not sure if it was possible. The point, members of the jury, is that the defendant had an obligation to do something about the fact that there was no light out there. And they chose not to. And they knew this was an issue because you heard about that previous incident in 2010. Another employee on those stairs tripped in the dark and hurt himself. And their own employee, their own manager, said that the defendant should provide adequate lighting to make sure that this kind of injury doesn't happen in the future. And they didn't do that. Years went by and they did nothing to rectify what was an obvious problem. So on January 29th, 2019, when Mr. Gilmore was out there in the dark, history repeated itself and he fell and he was hurt. They could have just installed an automatic timer. They could have installed a switch. As unwilling as Ms. Geller was to admit that on the stand, they could have done that and this wouldn't have happened. The fact that they chose not to makes them responsible for the consequences. Now, in addition to the lighting, the defendant had a responsibility to put safety railings on those stairs. Now, you saw those stairs today. You saw this picture. This is what the defendant could have done. This is what other businesses in that strip mall had done. Install safety railings on the exposed side of the stairs so that when your employees are going up and down, they have something to hold on to. They have something to protect them if they trip and fall. But not only did the defendant not have these installed, they specifically asked that railings be removed so that they could use that area to accept deliveries. But as much as they want to claim, they claim this was a loading dock, but they also acknowledge today that their employees use this area for all kinds of other things, for removing trash and for taking smoke breaks. And because of that, members of the jury, because that area was used for so many different things, the defendant had a responsibility to keep all those people safe. And they didn't do that because you saw pictures today of those stairs with no railing, with no safety rail along the wall, with absolutely nothing whatsoever for people to hold on to or steady themselves when going up or down those stairs, with absolutely nothing whatsoever to prevent them from falling to the ground below in the event that they tripped. And members of the jury, you saw this picture, Exhibit 3. You see in the corner of that step a hole where the railing used to be, and we showed you, the plaintiff explained to you, this is exactly where he felt his foot slip before he fell. The defendant can try to confuse you all you want, but use your common sense, members of the jury. Someone saying, as soon as my foot goes on that step, I feel it slip and fall, and look what is right there, worn concrete and an open hole. That is what caused the plaintiff to fall, and that is what led to his injuries. And that step is in that condition because of the defendant's own choices. Now, in response to this, what did they bring you? They brought you the results of an OSHA investigation conducted in 2018, and they highlighted the fact that that investigation didn't lead to any citations. But members of the jury, you saw Exhibit 38. You saw the email that discussed that OSHA investigator's unwillingness to provide citations. So you can't actually trust the results of his investigation. And don't forget, members of the jury, don't let defense distract you. Just because there were no citations does not mean this area wasn't dangerous. OSHA is a governmental body who is reviewing workplaces to see if they violate any specific regulations. But no violations of those regulations does not equal safety. The question of whether or not this area was reasonably safe is an entirely different question. And OSHA regulations, yes, they are not dispositive. They are informative, but they do not answer the question that you are here to answer today. And that question is, did the defendant use ordinary prudence when maintaining this area? An area they already knew was dangerous because an employee had already been injured there. an area where they removed the very railings that were there to keep their employees safe, an area that they subsequently did nothing whatsoever to secure. And now they're here trying to claim that they're not responsible for their employees' subsequent injury. There was no lighting. There were no railings. And that door that led out to the back platform swung so far out onto that landing that on January 23rd, 2019, Mr. Gilmore had to try and move around it and risk falling off the edge of that ledge. You heard about the regulation that said that when that door was open, it could not obstruct the walkway by more than 7 feet, and you saw that picture. It obstructed the majority of the walkway. There was a foot, if that we see right here for Mr. Gilmore to walk around and get into that door. This is clearly a textbook violation of the OSHA regulations, members of the jury. So when defense counsel comes up here and tells you how they didn't violate any OSHA regulations, remember that. Remember that they're basing that on the report of somebody unwilling to issue citations, and remember how clearly this picture shows a violation. Now, these statutory failures aside, the defendant also didn't warn their employees about the dangers outside. They could have posted some kind of notice saying, no railings, there's a fall ledge here, you should be careful, but they didn't do any of that. They had an obligation to do that and they didn't. And when I asked Ms. Geller about that on cross-examination, she thought it was amusing, I suppose. As unwilling as she was to admit the responsibility that she had to warn her employees about the dangers she refused to fix, she came here today and thought that it was funny that she was testifying about whether or not her company contributed to an injury so severe that a man had to leave his job. Members of the jury, that is disgraceful. But that's what you get from a company who doesn't care about safety and doesn't care about protecting its employees. They weren't going to come here today and take responsibility. The least they could have done was come here and be respectful of how Mr. Gilmore's life has been irreversibly altered. Members of the jury, time and time again, the defendant has failed their employees. They failed to provide safety railings. They failed to provide adequate lighting. They failed to provide warnings. And on January 23rd, 2019, those failures caused Jordan Gilmore's injuries. Because when he felt his foot slip, there was nothing there for him to hold on to. When he went over the edge of that railing, there was nothing there to break his fall. So when he hit the ground, there was nothing to stop the horrible knee injury that irreversibly altered his life. Today, you have the opportunity to hold the defendant accountable for those consequences. Their failures, their fault for the consequences. They failed Jordan Gilmore. So look at the evidence and the testimony that you have seen today, members of the jury. And when you get to the question on the jury sheet about whether or not the defendant was negligent, you can confidently answer yes and find them liable. Thank you.
253 remaining. Okay. You've got 2252 left. Hold on one sec. I'll get you set up. And whenever you start talking, I'll start timing.
Thank you, Anna. May it please the court. When a person gets hurt, especially when they suffer the kind of injury that the plaintiff suffered, well, it's natural to point the finger. It's natural to want to lay the blame on someone. There's a car accident. blame the faulty bricks. There's a slip in aisle 4. The floor must have been wet. The truth is, sometimes people get hurt and there is no one to blame. Sometimes a person walks up a flight of stairs that they have climbed 20,000 times before. But this time they stumble. It doesn't mean those stairs were dangerous. And it doesn't mean that those stairs caused that stumble. Just because there's a fault doesn't mean there's fault. Now, as the defense, it's not our job to prove that. It's not our job to prove anything because we have no burden of proof today. That burden rests with the plaintiff and the plaintiff alone. They have to prove their case, every single element, more likely than not. But today, there were 2 elements of their case that they had to prove, that they failed to prove. They failed to prove that the area outside of Chimes was unsafe. And they failed to prove that the area outside of Chimes caused Mr. Gilmore's injuries. So let's look at those one at a time. The first element that the plaintiff were unable to prove is that the area, the conditions outside of Chimes were unsafe. And today, you heard from 2 experts. They both talked to you about OSHA regulations. I know that the plaintiff just stood up and they told you, you cannot trust the defense's expert. But let's actually take a step back and look at what those experts do, who they are. Because one of the people who testified to you about OSHA regulations, well, they're an OSHA inspector. That's their job. The plaintiff, they tried to show you an email, they said, well, that OSHA inspector, you can't trust that OSHA inspector. Well, because they don't give citations. Members of the jury, you didn't hear that that OSHA inspector was fired, although they didn't do their job. You saw an email. But you also heard the testimony of that OSHA inspector, and they said, yeah, I still work for OSHA. I've been doing this for 13 years. Let's take a closer look at the person the plaintiff called, their expert. Let's look at who their expert works for. They work for the plaintiff. They hired him, and lo and behold, he agrees with them. So let's talk about which of those 2 experts is really the one you want to trust when it comes to OSHA regulations. Because the person who testified for the defense, like I said, they've worked for OSHA for 13 years. They've conducted hundreds of inspections at job sites. The expert on OSHA regulations that the plaintiff called has never even been part of a government inspection. Our expert came to an official governmental determination of if this business violated a law. Their expert had an opinion. So what did our expert, the OSHA inspector who talked about OSHA regulations, tell you? Because, well, she actually visited the Chimes department store. She went into Chimes, she talked to managers. She went through those doors that the plaintiff keeps talking about. Went up and down those stairs that the plaintiff keeps talking about. And after she'd done that, well, did she say, well, these stairs, you can't possibly use those stairs? No. She determined that those stairs were safe. No citations, no violations, no. She said these stairs did not violate the safety code. The plaintiff today, they've been big on descriptions, calling things dangerous and unsuitable and inadequate. If all we had was the plaintiff's descriptions, you might believe that people were falling off these stairs left and right every single day. But let's look at what's actually happened at Chimes department store for the 14 years they've been in that spot. And specifically, let's listen to the words of the plaintiff. Because the plaintiff went up those stairs every day. 20 times a week they used that staircase. Up and then down. Down and then up. They did that 50 weeks a year. 10 years. About 20,000 times. Think about that, members of the jury. The plaintiff used those stairs 20,000 times. With the same conditions. Didn't fall off, didn't slip, no injuries. Because those stairs were safe. That's why the plaintiff told you those 20,000 times, up until January 22nd, 2019, I never even had any trouble. And of course, that's really just the experience of one person. But when you take all of the employees who used those stairs, what becomes even more clear? Every cashier, every clerk, every person who took out the garbage, every person who wanted a smoke break down there, delivery people, managers, they all used that staircase. And in the 14 years that that staircase was used, without a railing, there's only one other person who ever fell. And that person, they slipped on loose gravel. There's no evidence of loose gravel in this case. I want to show you the jury instructions. As the judge will explain, the standard here, it's not whether the stairs were perfectly safe. That's not possible. The question, it's also not who was in control. The plaintiff, they spent time talking about that in their closing, and you're not going to see that on the jury instructions. So I want to make sure that it's clear. It doesn't matter. Because what matters is the standard. And the only standard is whether those stairs posed an unreasonable risk. When a federal safety inspector tells you those stairs are safe, it's not an unreasonable risk. When there's one accident in 14 years, it's not an unreasonable risk. When the plaintiff himself has taken those stairs 20,000 times, that's not an unreasonable risk. So for question one, you can answer no. And if that's your answer, then you're done. There's a second, separate reason why Chimes isn't liable here. And that's because the plaintiff failed to prove a second element of their case. They failed to prove that those conditions, those stairs, caused Mr. Gilmore's injuries. You see, the plaintiff, they couldn't just prove that the plaintiff himself was injured while he was on those stairs. They had to prove that he was injured because of those stairs. And the plaintiff's own testimony, well, it undermines that finding. And they asked all sorts of things, and they told you all sorts of things in their closing. They talked about lighting. They talked a lot about how dark it was. But when I asked the plaintiff, he said, oh no, I didn't miss the step. I didn't go to put my foot down and was unable to see. No. They talked about the disrepair of those steps, but I asked the plaintiff, he said, oh no, I didn't feel that step crumble away. I didn't feel myself stepping on a pipe. In their closing just now, the plaintiff, their attorney stood up and she said, Mr. Gilmore put his foot in that hole. That's what caused him to slip and fall. You didn't hear that evidence today. You didn't hear that testimony today. In fact, you heard the opposite. Mr. Gilmore got on that stand and he said, no, didn't feel a pipe. So what happened? Well, that's the problem for the plaintiff, members of the jury. Because all we know that happened is something. And that's not enough for the plaintiff. Because they can't just prove that something caused him to fall. They have to prove, their burden is to prove that those stairs caused his fall. So why? Why then did the plaintiff fall? Because he slipped. Because sometimes people just slip. Members of the jury, I know that's unsatisfying. It's certainly less sensational than the story that the plaintiff just got up here and told you. Sometimes the truth, it's not so exciting. And the evidence, well, it bears up when you look at it. How many times do we stub our feet on a couch? Doesn't mean the couch moved. It doesn't mean the living room was suddenly unsafe. You stubbed a toe. It happens. It's not the couch's fault. It's just because we're human. Let's take another look at that verdict. The plaintiff had the burden of proving that those stairs caused the plaintiff's injuries. And the truth is, we don't know what caused the plaintiff's injuries. But that was the plaintiff's job. That was their burden. Because we don't know, because something happened, that's why you have to write no to question 1. I want to make sure I'm very clear on this last point. We are not criticizing the plaintiff for losing his balance. We're not trying to blame him for falling. Tripping one time after climbing those stairs 20,000 times, that doesn't make him careless. That's what makes him human. Well, let's not blame Chime's department store for that. Find the plaintiff. Find in favor of the defendant, Chime's department store. Because just because there's a fault doesn't mean there's fault. Thank you.
All right, any rebuttal?
Yes, Your Honor.
Give me just 1 second to get your time set up. Okay, so you got 2 minutes and 53 seconds left. Whenever you start talking, I'll start timing.
It only takes one fall for there to be fault. You can walk down the same aisle in a grocery store every week, but if one day when you come along there's water and you slip and fall, then that grocery store is responsible for what happened to you. You can drive your car down the same street every day, and if one morning there's a driver driving recklessly and they hit you, well, that driver can be responsible for you. And you can walk up and down the same set of stairs every day at work for 10 years. And then if one day you're on those stairs in the dark and you slip, and the fact that there's no protection whatsoever there to keep you from falling over and hurting your knee leads you to being irreversibly injured, then your employer is responsible for that injury. Members of the jury, do not let OSHA regulations distract you from the evidence you saw today. The pictures you saw today of that landing make it abundantly clear. The concrete was crumbling. There were no railings, there were no handrails, and there was no light. All of those taken together make it extremely obvious that this was a dangerous stairway. And the simple fact, the coincidence that nobody had fallen and hurt themselves that we know of in the intervening 9 years since the last person fell, well, that doesn't matter. Because on January 23rd, 2019, Jordan Gilmore did fall, and he fell as a result of the defendant's failure to keep him safe. Don't let their math distract you from their responsibility. It's their responsibility every single time their employees use those stairs to keep those employees safe from unreasonable dangers. On January 23rd, they failed. Because they failed, Jordan Gilmore fell and horribly injured his knee. Hold the defendant responsible for their failures. Find them liable. Thank you.
All right, guys, so we're going to turn our ballots in, and then we'll do a brief commentary once we get the go-ahead that everybody's turned their ballots in. So judges, go ahead and turn your ballots in, and we'll knock that out real quick. All right, everybody. We can go ahead and turn our cameras back on, judges. I'm going to be a pain in the patoot, and I'm going to go first with my criticisms because I've got to make a phone call for work. So I'll let y'all continue after I finish. My name's Kyle Gardner. I'm a law clerk for the magistrate here in Waco, Judge Mansky. I'm in my second year of my clerkship. I thought y'all did a great job. I'll just give y'all a little bit of feedback for each one of you. One thing that I would say is, the plaintiff, the witness, right, was obviously giving you a little bit of trouble. I thought at the end of the closing, you kind of made some hay out of the laughing thing. I almost would have made that the theme of the closing. Why not, right? That's the business owner. She's laughing, finding it kind of lighthearted. And I mean, I also would have talked about how she wouldn't answer your questions, right? I mean, you can make some hay out of that as well. That, you asked her point blank, could you have done this? And listen, she will not answer that question because she knows the answer is yes. Right. I mean, and she eventually answered yes, but, make some hay out of that. That would be my advice on that. Also, one thing that I've now heard a couple of times now is we don't know what happened to cause the slip, right? That's what, defense was going with it, that, he doesn't know what happened. You can kind of turn some of his rhetoric back on him, right? With this theme, especially, right, with no fault. I mean, in general, right? I mean, when you fall, does anybody really know? I mean, unless it's like something tackling you, right? I mean, generally that's the nature of falls. It doesn't mean that, no one's at fault necessarily, right? I mean, it's just, that's kind of the nature of a surprising incident, as well. I mean, I was surprised, how did it happen exactly? Well, I don't know. I'm not, a ghost outside of my own body. Okay. So for defense, I would say that the theme, was fine, but the one thing I'll say about it is the wording of it. Especially with Zoom microphones, a fall, doesn't equal fault. Especially the first time you said it, I thought you were saying the same word twice. And so that's just, acoustics, something to be aware of. Those words are very similar. It might kind of sound like two repetitive words. Watch it with the demonstrative with the calculator. You probably should have asked if you could have done a demonstrative with the calculator instead of just throwing it up. You can tell I'm a pretty easygoing person, but if you get a particularly imperious judge, they might not like that. And plaintiff's counsel, you could have objected at that point too, right? Just what is this? Objection. What are we doing here? Getting stuck on the calculation, I didn't think that was terribly important for both of you, right? I mean, if she was going to stick on it, I just would have gone down to the 10,000. Who cares, right? I mean, it's a big number. That's the point that you're making. So no reason to get our wheels all spun up about that, right? So that's all I've got. I thought it was a great round, and I wish you both the best of luck. And so now we'll turn it over to, let's do Miss Cunningham first, and then I'll let y'all decide. I'm going to go make my phone call.
Can you guys hear me okay? I have a really bad internet connection, so if you guys can't hear me, someone hold their hands up and I'll just type in my comments. I'm Misty Cunningham, and I am a board certified personal injury attorney in Texas. I work in defense. I've tried and handled this exact case multiple times. You both did a great job. Thank you guys for competing. Can you guys still hear me? Can you hear me okay? No, okay. I'll put my comments in the chat section. Thank you guys.
I guess, wait, Judge Metz, do you want to go?
Sure.
Okay.
I just want to compliment all of both of their competitors. You did an excellent job. I think the one critique I would have for the plaintiff is that sometimes, just to kind of echo on the difficult defense witness, I think there were a few times where you had said you were starting to press and kind of go back and forth with your kind of hostile witness, and there was a point where there was going kind of back and forth, and then there was kind of an abrupt moving on. And so I think maybe sometimes it can be helpful to kind of balance wanting to press your point, make your point heard, And also, I mean, I did love the comment, you know, what do you find so funny here? But then there was kind of this awkward pause. I don't think it's, I mean, it wouldn't be appropriate to start arguing in that, in that timing, but I think your gut instinct as far as handling the difficult witness was spot on. But I agree with later comments about maybe trying to weave that in a little bit more into your closing. But overall, I thought you did a great job with the direct and cross of the witnesses. My comment on the defense side, I just want to commend the closing argument. I think you did a great job of trying to, I mean, the theme of we're all human, you know, things happen. It was a great theme. I think especially on the defense side, it's extremely difficult to try to soften your position, especially when you represent the big company. I do want to be, so my last comment is for the both of you. I think you should be very cautious in these types of closing arguments and even an opening, and just generally. This is a slip and fall case. It is not a car wreck case. It is not a grocery store slippery aisle case. I think it's somewhat, it can be a little tricky to start drawing comparisons to those kind of metaphors of different types of cases. You know, when someone falls and there's water, you know, they're people who need to be held responsible. I think you might want to on both sides of that argument, you might want to be careful about drawing comparisons to this particular fall, which was there was a slip. We don't know what caused the slip, but especially in the stair context, if that makes sense, especially if there's no evidence that really says, you know, that clearly says it was raining, or there, you know, if there wasn't if there's still a lot of factual ambiguity about what actually caused the slip. So, but again, great job on both your parts. So those are really minor critiques. Like I said, I would try to find maybe some more tangible metaphors for your jurors to kind of attach to, which is why I liked the couch, you know, bumping, you know, we're human. I like that kind of element to it, but I think we just want to be careful about drawing this particular case to other types of negligence cases. But great job to both of you.
Okay, I'll wrap up. I'm David Kent. I'm from Dallas and have been trying cases for way too long, both personal injury and commercial litigation cases. I really enjoyed your presentation. I thought you both did an excellent job. I'm always impressed with the quality of work that is done on such a short time space. I'll give you a few comments, but I do want to mention one particular thing about the previous comments. I agree generally with all the comments that have been made, but the very last comment about stubbing your toe on the couch, I, for one, really related to that. I thought that was great because it is true. We do that so frequently. You are walking along, you stub your toe on the couch on something, doesn't mean the couch was at fault. Doesn't mean you were at fault. I loved the line. It didn't mean he was careless. It just meant he was human. Really loved that line personally. But I do concur with the comment about you have to be careful about drawing comparisons and making analogies, because no matter how perfect you think it is, almost certainly somebody else is going to say, well, wait, here's a reason why it doesn't fit. Apart from that, let me give you a couple of other comments. One is something that I heard today and I heard yesterday in a couple of CLE speeches I've attended, and that is avoid repetition and avoid belaboring the obvious. This is really simple, some of the themes, and it doesn't need to be hit over and over and over again, repeated constantly. You make your point, move on. I thought on the defense opening, just because there's a fall doesn't mean there's fault. The first time you started with that opening sentence and the first time you came back to it, I thought he ought to stop right now. You've said everything you need to say. I don't need to hear anything else. And I really did think that the further you went on about, now let me introduce the owner of Chimes, now let me tell you about the OSHA inspection, now let me tell you about what you're going to hear, really didn't need it. I thought you made your point. It would have been very bold, I would say, to stop right then and there after, what, a minute and a half, but you had said everything you needed to say. Second thing I would say is for both sides, be careful about pandering and trying to express a comment that really is fairly insincere on the plaintiff side. When you said, "Oh, I'm sorry to hear that you were injured." What do you mean? The way you said that, it sounded as if you were saying, "Oh, golly, that's news to me. I've never heard that before. I'm so sorry to hear that you were injured." Of course you know he's injured. That's the whole point of the lawsuit. So it just seemed insincere and kind of pandering to me. And the same thing happened on the defense side when you said to the owner of Chimes, "I want to be upfront with the jury. Did you know that employees were using the loading dock steps?" Well, of course she knew that. It just seemed totally phony to me to say, I want to be upfront about something that there could be no possible question about. So be careful about that type of thing. I know the purpose of it is to try to seem genuine, but when it's a setup for an obvious point, it doesn't necessarily come across that way. Two other comments, and then I'll be quiet. One, just out of curiosity, and maybe I didn't hear it correctly, but I thought on the plaintiff side, you were talking about on the Exhibit 3A photo of the stairs. I thought I heard you say, "I make a motion to preserve Exhibit 3A as a demonstrative aid." And I didn't understand that, as opposed to simply saying it's in evidence, because a demonstrative aid does not go back to the jury box. It doesn't, it's only used for demonstration purposes, explanatory purposes. And of course, you wanted that photo to go back into evidence with the jury when they were deliberating. Maybe I misunderstood it, but that just stuck out to me. A second thing I would say, and this also was just a thought that occurred to me over on the plaintiff side, when you were talking about lights, and I don't know if this would be kosher or not, but to bring in something like this. But one thing that occurred to me was, what about arguing, do you watch TV? Have you seen how many at Christmas time, how many times did you see the as seen on TV ads for the battery operated motion detector lights that you can put up with adhesive on the wall? And the whole point of it was it gives you lighting where you need it, when you need it, for $20. For $20 at Home Depot, you can get this, and you can stick it on with adhesive, and you're not damaging the property, and you're not having to ask anybody's permission, and you provide lighting right then and there. And the only obligation you have is to change the batteries every now and then, and to remove it from a wall, and use some Gooby Gone to get off the adhesive on the concrete wall when you leave the building or leave the premises. Just a thought. And I've done plenty of these mock trials, and I know that there's frequently some concern about trying to bring in something so extraneous, but I think that might be a fair way to do it. But anyway, I thought it was a great presentation by both sides. You're to be commended, and good luck for the rest of the competition.
Thank you so much.
Thank you to all the
of our
judges.
Jack, it was a pleasure. Good luck.
Yeah, thank you.
Same to you.
Everyone.
Okay, I guess we're done. Are y'all moving on now? I guess so. Well, goodbye. Enjoyed it.
Thank you, Judge.
Bye-bye.
Have a good one.